you have heard about this case and focus entirely on the evidence that is presented to you in this hearing. And at the conclusion of that evidence, I ask that you uphold the district's recommendation to terminate Ms. Rinderly's employment contract. Thank you.
Thank you, Ms. Colvis. All right, Mr. Goodmark, you want to make an opening statement?
I would. Thank you, Your Honor. Good morning. I've introduced myself. My name is Craig Goodmark. This is Mike Tafalski. We represent Katie Rinderly, who is a teacher at Due West Elementary. We do appreciate your time. I know it's an ask to come and sit for one of these tribunals, especially if it's going to be multiple days. It's not many times, and I've been doing this for decades, like the others here, that we do this for multiple days, so I do appreciate your patience. Opening statements are roadmaps. It's the opportunity to preview the evidence. But remember, they have to deliver the evidence. It's not enough to stand up here and tell you, it happened this way, it happened that way. That's not evidence. The evidence will come when the witnesses get in the box and the documents are shown. And that's what you really need to be paying attention to, because I've already heard a few things that I don't know that the district is going to be able to deliver on. And so I want you to just pay close attention, because they've promised, and I think over-promised, in this situation. Clearly, there's differences of opinion. We've got a full hearing room here today for that. But that doesn't negate the district's obligation. You know, this is a legal proceeding. They have to produce evidence, not argument. And so I'd ask you to pay attention today, because the roadmap was laid out, but I certainly don't think that the district's going to be able to travel all the way down that road. We're here today to defend Katie Rinderly from the culture war. It's come to Cobb County. It's come to your schools. It's got no place here. We're here to prevent a group of parents with a culture war agenda from running out a good teacher from your district. The district has notified Katie that she violated policies, was dishonest, was unethical on June 6th. Unbelievably, one day before this matter started, you'll hear evidence that the district paid Katie to go to Athens as part of a training for leadership, because she has been leadership in this district for 10 years. This is what happens when politics overtakes education. Good educators like Katie Rinderly will be sacrificed. Make no mistake, without the complaint of a parent, this circus never comes to town. But these procedures, the reason we're all here, the Fair Dismissal Act itself, you know, you're educators. It's here to ensure that the teachers, hardworking people in classrooms that are responsible for the next generation of Cobb County citizens, are protected from this type of ideology and politics. Fair dismissal laws exist for this very reason, and today I expect they'll be put to the test. Katie has been charged with insubordination, willful neglect of duties, and other good and sufficient cause. The evidence today, however, it will not show any such thing. The district is going to present secondhand accounts of what happened when the book was read, My Shadow is Purple. Secondhand accounts of student-led discussions that took place before the book was even read, and students' reactions. The district has indicated, and we'll hear, that there were no other parents in the classroom that day, but they'll bring parents here to tell us about their complaints. They'll not have all the parents come in, though, to testify, and that's important, because there's evidence that only a few complained, and most were after an organized campaign by the parents was started to get those complaints. The district's going to attempt to create the appearance that Katie was a bad teacher. Of course, again, you heard, the evidence will limit them, because evidence here is what matters. And the evidence is, you're administrators, you know, we evaluate educators every year. And as an administrator, you're legally obligated to put what you see and what you think about that educator in the evaluation. And that is the evidence of performance. The evidence will show her that they are required to document negative performance issues, and the evidence will show there simply is none. The district during this hearing has the burden, and that means they have to show by a preponderance of the evidence that Katie did what they say she did. They have to show each and every element of those charges exist. They have to they have to prove insubordination, and that is a willful disobedience, a refusal to obey. There has to be a reasonable, valid, understandable rule that was violated. And you've already heard words like controversial, sensitive, divisive. Those are new words in education. You guys are old-time educators. You know that didn't exist. That's new. 2022, the legislature passed a law, and now we have these policies. Nobody knows what they mean. Critical will be that there's no direct evidence that Katie willfully disobeyed anyone at all. To make things worse for the district, they'll have to prove that her actions were in the face of these reasonable rules. And as a tribunal, you'll have to decide if those rules make sense to a reasonable person. Similarly, the district has to prove a willful neglect of duties, and that is defined as a flagrant act or omission, an intentional violation of a known rule or policy, or, and this is important here, a continuous course of reprehensible conduct. Listen today for evidence of reprehensible conduct. Parents complain. Teachers know that. They're on the front line. You know that. You fielded more than 1,000, I'm sure. Parents complain. That's not the same as an educator engaging in reprehensible conduct. And the evidence today will show that they didn't reach the level of that, if the level of anything at all. There's no flagrant acts. The evidence will show there was no intentional violations. And most importantly, you'll hear today that nobody understands what these policies mean or how they're to be enforced. I fully expect today's testimony to present political, ideological differences, but that's not school district policy. And there's a critical piece of this. There's a difference between the politics and the policy. Employees follow policies. Politics, the politics of outsiders, the politics of angry parents, those do not come into the classroom. And they do not get to say to the Cobb County School District who stays and who goes. That's what the policies are supposed to be for. The district has also included this catch-all charge of other good and sufficient cause. The evidence today will be some patchwork of testimony from a principal, that others, and all of a sudden a small group of noisy parents complained. And now this highly educated, this highly respected, talented, experienced, credentialed educator is somehow going to be lost to Cobb County because of an angry group of parents with a political agenda. The district will go back and try to present evidence from the year before, and we'll have discussions about that. But past, as I told you, in education is really hard to recreate because documentation is really the key here. What do the documents say? What do they show? Did these complaints that parents had, which all parents have, rise to the level of concern for Katie's supervisor? The evidence will show that it didn't. The very person who now claims that she's lost confidence is the person that evaluated Katie year over year. And the evidence will show that she hadn't lost confidence up until the day before March 8th when she read the book and had sent Katie to Athens, spent her own money out of her budget to send this educator to be trained and to be a leader in her community. Katie Rinderly shouldn't be punished for trying to present a book that was chosen by the students. And you heard the district open this. The evidence will show there was no lesson. There was no opportunity to opt out. The evidence will show because this was a book that was chosen by the students. This wasn't a lesson plan that was created weeks in advance. This was a read aloud, and she let the students choose the book. Other parents who had never read the book before complained. They thought the book was about LGBTQ issues or controversial issues. The evidence is going to show they didn't even read the book before they complained. The evidence will show nobody read the book before it made it all the way up to the superintendent's office. That's important. Again, politics is not policy. At the end of this hearing, the tribunal will be asked, you will be asked to determine if the district has carried its burden. Again, that's a preponderance of the evidence that she should be terminated, having, up until this point, never had even a negative evaluation, be terminated. We ask for your attention, as I've asked, and patience. We know that it is a difficult thing to sit there all day. We know it's, and we'll try to be to the point. We'll try to be succinct and to not be repetitive. But we ask that you be patient. And we ask for your attention as we protect Katie Rinderly's job, her livelihood. We protect Cobb County educators. We're protecting these public schools from culture wars and culture warriors, outsiders, and even those that happen to be doing the hiring and the firing. It's simply no place in Georgia's public education system to replace policy with politics. Thank you.
All right, thank you, Mr. Goodmark. Let's do a couple of housekeeping things before we begin. First of all, members of the media, how are we back there? Can everybody hear and everything okay? Okay, good. And we've had a couple of people come in and out since we started. So I'm just going to ask both of you to just kind of pay attention to, we've got both of you have asked for the rule of sequestration. Just make sure that your witnesses, any witnesses for either party, are not in the courtroom.
That's difficult for us because we've subpoenaed some people we don't know. So
Okay.
we'll just ask you to make an announcement and say if you've been subpoenaed to be a witness or you are a witness, please identify yourself and leave the room.
Is anyone in the courtroom that's been identified either as a witness or potential witness in this case? If you have, please step out now. But just kind of identify yourself first if you're in here as a witness. Okay. And I'll try to watch Mr. Goodmark as people come in. But again, I know you may not know, and Ms. Colvis may not know either, as far as people that have been subpoenaed. All right, and then lastly, members of the panel, and then also council. At any point in time, y'all need a break or anything, just sort of signal to me and let me know. For y'all as well, if you need a break, just let me know, and we'll take one. We've been going just a little over an hour, so we're ready. If you're ready, we'll keep going. We'll push forward. All right, Ms. Colvis, you can call your first witness.
The school district calls Ms. Catherine Rinderly to the stand for purposes of cross-examination.
We object to this at this time. It's inappropriate. We'd ask that the cross-examination be limited after we present her direct testimony. If that's not possible, the district insists on going forward. We will hold our direct until we present our case.
Which position, Ms. Colvis?
The school district listed Ms. Catherine Rinderly as a witness that it may call for purposes of cross-examination. She was given notice, and we have the right to cross-examine her.
Does the district feel like its case will be harmed if it just waits until cross-examination after she's testified on direct? We
prefer to call her now.
I think, Mr. Goodmark, they have the right to call for cross-examination, so I'll allow her to call him. Ms. Rinderly.
Thank you. Where do you want it, Mr. Chair?
Craig, that last chair right now, the last one on the end is going to be where the witnesses are. And I put
You're going to publish.
Court reporter, will you swear in the witness?
yes.
You can give me my own book.
Okay. Good morning, Ms. Rinderly.
Sorry, good morning.
My name is Sherry Colvis. I'm representing the school district. I'll be asking you a few questions today. During the 2022-2023 school year, you were a target teacher for Due West Elementary School, correct?
That's
She's
correct.
actually leading.
Your Honor, we called her for cross-examination.
It's established that she's adverse.
I'm say that again, Mr.
We'd like to establish that she's adverse.
Your Honor.
Okay. I don't think that's required, but I'll allow the question. She's got her own cross and she can lead. So I'll overrule the objection.
A target teacher is often commonly referred to as a gifted teacher, isn't that correct?
Yes, a gifted specialist.
And you have been a teacher in the Cobb County School District for approximately 10 years, am I right?
That is correct.
And you understand, don't you, that as a teacher, you have a duty to comply with all of the Cobb County school policies, don't you?
Yes.
We have a notebook in front of you that has exhibits in it. We would ask that you not turn to a tab until your attention is called to it, and perhaps if the hearing officer rules on the admissibility. Your Honor, I have another copy of this book as well. May I approach and provide it to him?
You may.
Is there any objection to this? Do you have any objection to this? Your Honor, there's no objection to the introduction of this exhibit. I will identify that it's School District Exhibit 1. May I pass out copies to the tribunal?
Yeah, no objection, Mr. Goodmark?
No objection.
All right, it's admitted without objection.
Just a bit of housekeeping. I don't know how this is going to go with the exhibits, but if you could identify them as the District Exhibit 1, because I'm going to identify ours as Educator Exhibit 1, so we don't have two Exhibit 1s. Is that fine?
That's fine. They've been labeled already, but they all have their own notebooks, so they'll be going in that notebook.
Yeah.
So I think we'll be okay.
But we just, for the record, we'll refer to them as district, and what are your
Educator.
An educator, okay.
Ms. Rinderly, you don't dispute, do you, that on March 8th, 2023, during your 5th grade target class, you read the book in front of you, marked as District Exhibit 1, called My Shadow is Purple, to your class?
That is correct.
Please hold up the book so the tribunal can see the cover. The character on the front cover of the book is wearing pants, isn't that correct?
The shadow or the character?
The child on the front cover of the book is wearing pants, isn't that correct?
Yes, that is correct.
And the shadow in purple of the child on the front page of the book is wearing a skirt, isn't that correct?
That is correct.
Please turn to the back cover and read the description of the book to the tribunal.
My dad has a shadow that's blue as a berry, and my mom's is as pink as a blossoming cherry. There's only those choices, a 2 or a 1, but mine is quite different. It's both and it's none. A heartwarming and inspiring book about being true to yourself by best-selling children's book creator Scott Stewart. This story considers gender beyond binary in a vibrant spectrum of color.
The school district would ask that you turn to Exhibit 2, which is School District Policy IFAA-R, Instructional Resources Selection and Acquisition. I understand from Mr. Goodmark there's no objection to the introduction of this exhibit.
All right, it's admitted without objection. Do the panel, do they have that? Or you?
No, I have that up. Thank you.
were doing so good with that so to this point.
Ms. Rinderly, you are aware that the district has adopted policy IFAAR, instructional resources selection and acquisition, are you not?
That is correct.
And you knew that before March 8th, 2023, did you not?
That is correct.
And you are aware that you have a duty to follow this policy, isn't that correct?
Correct.
I'd like you to turn to Part 2. Paragraph A, next little paragraph number 3. The header is non-school materials and outside presenters. Will you read that paragraph 3 for the tribunal, please?
All non-school print and non-print materials utilized in the instructional program by teachers, students, and guest presenters shall be supportive of the adopted curriculum for the course being taught and appropriate for the targeted audience. It is the responsibility of the teacher to review non-school materials prior to use and to inquire of a guest presenter information regarding his or her objectives and the contents of his or her presentation prior to the presentation.
Please identify for me the adopted curriculum for your students that addresses gender identity, gender fluidity, or gender as being binary or non-binary.
There is no curriculum.
Let's turn to paragraph B. This paragraph addresses the selection of supplemental learning resources, does it not?
Yes.
Okay. And it states that concepts, content, and vocabulary should be appropriate for the potential user, doesn't it?
It does.
The students in your 5th grade target class when you read this book were 10 and 11 years old, weren't they?
Yes.
You understand that some parents believe that 10 and 11-year-old children are not developmentally ready to have a classroom lesson on gender identity and gender beyond binary, don't you?
Objection. Calls for speculation. She can't testify to what parents believe.
I'm not asking her to testify to what they believe. I'm asking her to testify to her knowledge on the subject.
So restate the question.
Yeah. Do you know what parents believe on this topic?
Objection. What are parents? It's an unanswerable question.
I'll overrule that objection. I'll let you answer the question to the extent you understand it. Sure.
I believe all parents have different viewpoints.
Okay. You understand that many parents have not yet had a chance to introduce this topic to their children, don't you?
Objection. She calls for her speculation. She doesn't know what parents she's talking about or what they do in their homes.
Well, I'll overrule it to the extent that the witness knows the answer. You don't have to speculate. No, they're not asking you to speculate. So if you know the answer, you can answer it.
I'm not sure what she's asking now.
Do you know whether the parents of the students in your 5th grade target class had already had an opportunity to talk about this topic with their children?
No, and I don't know what topic.
The topic of gender identity, Ms. Rinderly.
No, I do not know that.
Can you understand why a family might want the chance to discuss the topic of gender identity, gender fluidity, gender beyond binary with their children at home first before it is introduced by a public school teacher?
Again, I don't know.
You can't understand that?
I mean, I don't understand. No, I don't understand the question. Can you repeat that?
Can you understand why a family might want the chance to talk about the topic of gender identity, gender fluidity, or gender beyond binary with their children before it is introduced to their children in class by a public school teacher?
Again, objection. She's asking what the parents' preferences would be in their home, and Ms. Rinderly can't be asked to testify to other people's preferences.
Again, I'll overrule the objection and instruct the witness. You only have to answer what you know, Ms. Rinderly.
I can't answer that.
You cannot understand why a parent might want that opportunity?
I can't answer what a parent may or may not want. I'm not, no.
Okay, so you've been teaching for 10 years?
That is
Is that
correct.
correct? Engaged with a lot of parents, is that right?
That is correct.
Okay. You don't have a general walking around knowledge that parents would like an opportunity to discuss topics that are going to be implemented in the classroom before you as a public school teacher do that?
Parents may want the opportunity to discuss many different topics with their child beforehand.
Let's turn to paragraph 10, please. Same page. This policy states that topics of a sensitive nature, i.e. social, political, religious topics, should be given a balanced treatment with both pros and cons presented, doesn't it?
Yes, that is what it says.
And you understand that the issue of gender identity or gender beyond binary or gender being fluid is a socially controversial topic, which members of this community disagree on.
Objection. She's again asked to give testimony, firsthand knowledge of the community understanding of this issue, and she doesn't have that. She doesn't have that knowledge. It's beyond, the question itself is inappropriate.
All right, I'll overrule the objection, but again, the witness is only required to testify about what her understanding is. That's what I hear is she's asking about what your understanding, but I'll ask you, Ms. Culvis, to repeat the question for the witness.
Ms. Rinderly, do you understand that issues of gender identity, gender beyond binary, or gender being fluid or not fluid is a socially controversial topic which members of the community disagree on?
No, I cannot confirm or answer that question, and I'm not sure what controversial means in this policy as far as how that would apply.
Okay. You understand, don't you, that issues of gender identity and whether gender is binary or fluid has become a hot-button political dispute in this country, don't you?
That it's a topic that people discuss, sure, yes.
That's the extent of your knowledge on the topic?
Say that one more time.
That's all you know. You don't know that the issue of gender identity and gender as being binary or fluid has become a hot-button political topic in this country?
Objection. She's asked, and now it's been answered.
Well, I'll overrule the objection just simply because I'm trying to make sure I understand the witness's answer. So if you will, just answer again.
No.
Okay. Not a hot-button topic. Thank you very much. And you understand that there are some families that have sincerely held religious beliefs that disagree with the concept that gender is non-binary or fluid. And some families that have sincerely held religious beliefs that believe it can be fluid.
Same objection.
Overruled.
Again, speaking to what parents and families believe, all families have different beliefs.
You acknowledge that this topic is sensitive, don't you?
Can you define sensitive for me? And what topic? Are we talking about the book?
Let's go with the topic of gender identity and gender fluidity. Can you acknowledge that that topic is a sensitive topic?
Objection. Is she speaking about the policy's use of the term sensitive? She needs to clarify that.
I don't think these are hard questions, Your Honor.
No, I
understand,
don't think so either,
Yep.
but you got to clarify sensitive because it's in the policy.
Yeah. I'll sustain that objection if you will. Just rephrase the question. Make it more clear.
Is it your position that this topic was not a sensitive topic as defined by the Cobb County School District policy?
No, I did not believe this book was a sensitive topic.
Okay. Let's talk about the topic itself, gender identity and gender fluidity. Is your position that those topics are not sensitive in this community?
Again, not understanding what you mean by sensitive per this policy, no. Social, political, and religious, this book and this topic, no.
So your position is that the community is united on the position that elementary age boys should be encouraged to dress in skirts if that's what they choose to do?
I think everybody has an opinion and is able to choose what they would like to wear, yes.
That wasn't my question though, was it? It was whether the
Sorry,
community is united on it.
I can't speak to if the community unites on what students can wear to school.
Your own GAE advocate acknowledged that this topic was volatile in your interview with the school district on March 24th, didn't he?
Objection, hearsay.
She was present, Your Honor. I'm asking her about something she was there for.
Can I see the transcript?
Then objection, lack of foundation. I mean, she's got to lay a foundation.
I'll sustain that objection.
All right, let's move to paragraph C. Paragraph 1 requires that teachers are responsible for completely previewing all supplemental materials, regardless of their source, before using them for whole class instruction. Isn't that correct?
That is correct.
Did you completely preview the book My Shadow is Purple before using it in your 5th grade target class?
Yes, I purchased this book at our school's Scholastic Book Fair, and as I was at the book fair before I purchased the book, I read the book in its entirety.
Thank you. Let's look at paragraph C2, permission. This paragraph requires that the teacher, principal, or designee of a school may require written permission, and it references a form, of parents and guardians prior to reading or viewing of supplemental materials if, in their opinion, the content may be of a sensitive nature within the school's community or the age group served by the school. Isn't that correct?
That is what the policy says.
Okay. And you did not inform your students' parents or request written permission from them prior to reading and using My Shadow is Purple with their children, did you?
There is no part of the policy where you have to receive permission for a picture book that's read aloud, and I did preview the book, and that my opinion was that it was appropriate for the age and grade levels that I serve.
Thank you, but I'd like you to answer the question, please. You did not, in fact, inform the parents of your students or request written permission from them prior to reading My Shadow is Purple, did you?
May require written permission if the teacher decides that it is needing to have, I guess, permission. And again, this was a book that I purchased with my funds at the school's book fair, and I previewed the book, and I used my professional judgment, and I aligned it to the standards that support gifted education and effective education for students. And it was not, I did not believe it needed permission to read this book.
So I'm correct, am I not? I'd just like to get an answer to the
No,
question.
there was no permission because it's not needed.
Okay. No permission and no notice, correct?
Correct.
And your position is that you exercised good judgment and discretion by not informing the parents ahead of time that you were going to use My Shadow is Purple in class.
I stated that I used my professional knowledge and my professional judgment when selecting this book and previewing this book that my students voted on and chose.
Okay, and was that professional knowledge and judgment good judgment, or do you regret that judgment?
Objection.
I like to believe I have.
Objection.
Hold on.
Objection.
What's the objection, Mr. Goodmark?
Object to the form of the question. She's using a term that has no definition, good judgment, bad judgment. She needs to explain that. Is that based on the policy, based on the standards, based on the duties and responsibilities of the position, or someplace else?
All right, I'll overrule the objection to Ms. Close. Just may want to repeat it again for the witness to make sure she understands it.
Is your position that you exercised good judgment and discretion by not informing parents ahead of time that you were going to use My Shadow is Purple in class?
Yes.
Okay. Your Honor, I'm going to be referring next to the school district's Exhibit 3, which is Form IFAA1. Ms. Rinderly, you can go ahead and turn to tab 3, and I'll pass these out. There's no objection from council.
All right, it'll be admitted without objection.
Can you identify this document for us, Ms. Rinderly?
This is the permission form for supplemental learning materials or resources.
This form gives an example on it, doesn't it, of showing a PG-13 movie for language. Isn't that correct?
That is correct.
And this form does not limit its use to things that are divisive concepts or race concepts, does it?
No.
And you were familiar with the requirement to use this form, weren't you?
Objection, objection, that's
No.
not the policy. She misstates the policy. There's no requirement.
You want to rephrase it? Ms.
You were
Curtis?
familiar with this form before March 8th, 2023, were you not?
The form for providing parents
The
permission
form that's in
for
front of you,
videos
yes, ma'am, Exhibit 3.
for supplemental materials.
Yes, ma'am.
It was not reviewed at the beginning of the school year, no.
You've been in the Cobb County School District for how long?
We have a permission form at our school to send parents for permission for videos that are over PG. Yes.
Okay. And is that a different permission form than the one that's in front of you?
It looks the same, requiring permission for videos that are over PG.
Well, let's take a look at it for just a minute, if you will. Tell me on this form where it's limited to just videos.
It's not. Rating and basis for rating it applicable. Supplementary and library media materials, so supplementary materials and then library media materials.
Okay, thank you. And let's go back to Exhibit 2, please, everybody. And let's go to paragraph D on alternative assignments under Part 2, which is the last page, page 5 of 5. Let's look at the paragraph D, alternative assignments. It states that professional discretion of the principal or designee and staff must be used in the use of supplementary materials, which might include topics of a sensitive nature as perceived by the community served. Parents and guardians of a student always have the option of requesting alternative assignments. Is that correct?
That is what the policy states.
And you agree that you are required to follow the policy, is that correct?
Yes, all policies you should follow.
You did not give your principal the opportunity to use her discretion on whether this material was appropriate because you did not inform her of your intended or potential use of this book with your class, did you?
This was not supplementing our instruction. This was a picture book, like with all picture books that we read across our school. We've never had to have permission for a picture book that we are reading. And so there was no assignment with this. There was no lesson with this. It was a picture book that my students voted on and that I chose at the school book fair. And I purchased with my own money, so it was outside of school. It was not supplementing any of our curriculum that we're covering and gifted.
Okay. So this book was unrelated to any of your curriculum, correct?
Objection,
It's-
mischaracterizes her testimony.
I'll sustain the objection. You can
Was this book related to your curriculum?
This book supports our effective standards, yes.
Okay. So then it is a supplemental resource, correct?
All picture books can be a part of that, and none of them have required us to have permission as well. And this was purchased with my own money, not something that the district had provided that I was supplementing.
Show me in this policy where it excludes picture books from the policy's scope.
My understanding is that if you non-school materials,
Show me what you're talking about, Ms. Rinderly, so I'm following along with you.
I preview the non-school material prior to use after selecting it at our school's book fair, and I use my professional judgment. It was not replacing a purchase at the district level or the local school level of curriculum that was purchased.
But nowhere in this policy does it say, hey, but for picture books, does it?
No.
And in fact, you did not give your principal the opportunity to use her discretion on whether this material was appropriate because you did not inform her that you were going to use this book, did you?
It is my understanding that I did not need to do that that was not part of the policy.
And I'm just trying to get a clean record. Could you answer the question, did you or did you not inform your principal ahead of time so that she had the opportunity?
No, I did not inform my principal.
Objection to that, she's asked and answered.
Well,
I'm going to overrule the objection, but I will instruct the witness, when you're answering questions, if you can answer with a yes or no, then answer with yes or no. If you need to explain your answer after you've given a yes or no answer, feel free to. We'll give you plenty of time to explain. Okay?
And Ms. Rinderly, you did not give the parents of the students in your class the opportunity to opt out of this reading or the opportunity to request an alternative assignment, did you?
No.
Now, it's my understanding from what you've told us that you bought this book at the Due West Elementary School Book Fair. Is that correct?
That is correct.
Okay. And am I understanding your position correctly that because the book was for sale at the book fair, it must have been approved by the county?
I used my professional judgment to understand that it was appropriate. I previewed the book before purchasing it. But yes, it was purchased at our school book fair.
Okay. So you're not relying on the fact that the book was at the book fair to allow you to be able to read it without vetting it or getting approval or notifying anybody?
Again, I read the book, so I used my professional judgment and I vetted before even purchasing the book.
Thank you. Is your position that you were allowed to read this book because it was at the book fair?
No.
Okay. You've changed that position, haven't you, over the course of time?
No, I read it. It was at the book fair, which that supports that it was a picture book that I would have felt comfortable choosing, even with previewing. So it only supported it even further, in my opinion.
But you understand that even though the book was at the book fair, you still had the duty to ensure that it was appropriate in compliance with these policies and that you previewed it in its entirety, correct?
Yes, I did.
Okay. And you understand that was your obligation regardless of the fact that it was at the book fair?
Yes, with all materials, yes.
Very good. No objection. Okay. Your Honor, the school district is next going to approach tab 4, IKBR, controversial issues. There's no objection from council.
All right, it'll stand admitted without objection.
You are aware, Ms. Rinderly, that the district has adopted the policy IKBR controversial issues, aren't you?
Yes.
And you are aware that you have a duty to follow this policy, isn't that correct?
Yes.
Turn with me to paragraph B1. on political or partisan issues. This policy requires that district employees refrain from using classroom instructions or their relationships with students to influence students, or through them their parents and guardians, regarding any one political or partisan side of an issue, doesn't it?
Yes, that is what it says.
And you are aware that you may not, in fact, attempt to influence students or parents regarding any one political or partisan side of an issue, aren't you?
That is correct.
In fact, reading this book to your class and the comments you made to your class were influential on one side of the issue, weren't they?
That is incorrect.
Nowhere in this book does it ever suggest that a boy should dress like a boy and a girl should dress like a girl, does it?
This book has more than just clothing in it.
Can you answer the question? Show me in the book where it says that boys should dress like boys and girls should dress like girls.
Can you show me what you're referring to, or tell me what page?
I don't think it's there, Ms. Rinderly, so I'm asking you to find it for me.
So then, I'm not sure what you're asking.
Okay. Nowhere in this book does it suggest that a boy should dress like a boy and a girl should dress like a girl, does it?
Does it not suggest that a boy should dress like a boy and a girl should dress like a girl?
Mm-hmm.
Doesn't discuss boys and girls in this book at all.
Oh, okay. You don't understand that the shadows are in fact a proxy for boys and girls?
So you're asking my opinion. So this book talks about the child in the book with their likes for different glitter, airplanes, engines, talks about their many interests and feeling that they should be able to choose any of their interests and explore all of their interests, much like gifted students have many interests, whether it's science and math and playing the saxophone.
But let's look at the book. We can go back to the front cover, right? On the front cover, we're not looking at science and saxophones and trains and planes. We're looking at jeans and a skirt, right?
Yes, that's what's on the cover.
Okay. And as this book continues, it sort of gets to the highlight of the book at the end where the student is going to a dance. Isn't that correct?
That is correct.
And the student ends up going to the dance in a tuxedo suit top, doesn't he?
He does.
And the student ends up going to the dance wearing a, ball gown skirt or something along those lines. Isn't that correct?
That is correct.
Okay.
The character has their parents make their outfit, yes.
Would you not agree with me that a skirt is traditionally worn by girls?
No, I would not agree with
Objective
you.
form,
Okay.
traditionally worn, is undefined.
I'll overrule the objection. The witness can answer.
No, I don't feel comfortable talking about a gender norm that, females, we can wear many different things, males can wear many different things.
Nowhere in this book does it ever embrace the position that genders are binary, does it?
Embrace the position that genders are binary?
That's right.
I'm not sure.
You're not sure?
No.
Okay. You've had a chance to review the book a few times by now, right?
Yes, many times.
This book, in fact, embraced the idea that children should be celebrated and encouraged to not stick to traditional gender identity and norms if they don't want to. Isn't that right?
No, this book discusses how students and children should be able to be supported in being true to themselves and, valuing one another for who they are and all of the assets that they bring with them.
Let's look at paragraph B3, please. Will you read that paragraph for the tribunal, please?
Can you repeat that?
Will you read paragraph B3 for me, please?
Is this back on Exhibit 4, Ms. Cole?
Oh, yes, I'm so sorry. Exhibit 4.
As addressed In OCGA 20-2-786, parents have the right to direct the upbringing and the moral religious training of their children. Therefore, district employees shall not improperly infringe upon this right.
And you understand and agree that parents have those rights, don't you?
Yes.
And you understand that as a public school teacher, you're not permitted to do anything that infringes on those rights, don't you?
That is correct.
Let's look at paragraph 5 at the end of the page on instruction. It says that during classroom instruction, objectivity on all issues shall be observed in instructional procedures, and balanced points of views on issues shall be presented, doesn't it?
It does.
And you did not present a balanced point of view on this issue, did you?
That is incorrect.
You instructed the students to refer to the character as they and them, didn't you?
That is incorrect.
You deny that you instructed the students to refer to the character as they and them?
A student was discussing their point of view before we had even read this book. And the student was making claims about what they believed the book was going to be about. And in that stated that they thought it was going to be about a boy who liked girl things because the character on the front of the cover was wearing pants and had short hair, which another student refuted and started a discussion with them. This is a student-led discussion. And the student made a point saying that we had not yet read this book, and you can't make statements that are using stereotypes. And another student brought in another student who was wearing a blue button-down shirt, and again, they were engaging in discussion. So to move this conversation forward, I reminded students of respectful conversation. I acknowledged the fact that what the student had said, that we had not yet read this book, and we do not have any information. And so to continue our preview, we could refer to the character as the character in the book or they.
Okay. So when I asked you the question that you instructed the students to refer to the character as they, you did, didn't you?
Objection, asked and answered.
I'll sustain it. I think she's answered the question.
Now, Principal Kale has been your building principal for about 5 years, is that right?
Yes.
And during that time, Principal Kale has frequently advised teachers to only use district-approved resources in instruction, isn't that correct?
Last year we had, she did direct us to use CTLS as our main source for curriculum.
Ms. Kale trained you and the staff to stay away from controversial, political, or sensitive subjects in your classroom, didn't she?
She pulled up the policy during our pre-planning and reviewed the language of the policy, and again instructed us to use CTLS for any curriculum. We didn't have an adequate training, but she did review the policy language, yes.
Due West had a back-to-school staff meeting at the beginning of last year for all staff, isn't that correct?
Pre-planning, yes.
Okay. And at that meeting, you were present, correct?
I was, yes.
Okay. And is this when you're referencing that Ms. Kale pulled up the policies and had a training on the policies?
This is when she overviewed the language, yes, during our beginning of the year slideshow.
This training included training on the IFAAR supplemental learning resources, didn't it?
Do we have the slideshow? Can I look at that?
I'd like to just remember what you remember. Did the training include training on IFAA, if you remember?
It had the language of the policies.
Okay. Including IFAAR supplemental learning resources, correct?
If I remember correctly, yes.
And it included training on IKBR controversial issues, didn't it?
It had the policy, yes.
Okay. And Ms. Kale repeated at that training that teachers should stay away from any controversial issues, sensitive issues, or topics that could be upsetting or infringe on parents' beliefs, didn't she?
She read the language of the policies, yes.
So you don't disagree with what I just said to you, do you?
I'm not sure if you're saying that she read the language of the policies or gave a separate training, but she read the language of the policies, which that is what is included in the policy.
Okay. You are a member of Due West Guiding Coalition, aren't you?
I am, yes.
And tell the tribunal what Guiding Coalition is.
It's our school leadership team.
And you regularly attend Guiding Coalition meetings, don't you?
That is correct.
Ms. Kale would also remind the Guiding Coalition members about the importance of only using district-approved resources. Isn't that correct?
Most of the time, our leadership meetings were over phonics this year, and I do believe that there was one occasion that she mentioned that she had spoken about maybe brain pop and using these resources. I actually was on a call with my professor that day. I was not at that meeting, but I had received permission from Ms. Kale to not be there. But that is, she did overview that, I believe, with a brain pop discussion.
There's a 5 skip, okay. And Mr. Goodmark, no objections to District
No, I
6?
do have an objection to this. I'm going to ask her to authenticate it and lay a proper foundation. So we asked the tribunal.
Well,
not to
let me
look
just
at it.
ask the tribunal panel member not to look at District Exhibit 6 just yet. Just hold off just a minute.
You're familiar with Exhibit 6, the local school process for acquiring supplemental instructional resources, aren't you?
Yes.
The district would tender it into evidence.
No objection.
It's admitted without objection.
This is the language from the policy. I've never seen this before, but I'm trying to read over it quickly since this is the first time I've seen it.
Take your time, Mr. Rinderly. Just look through it. They're asking you if you're familiar.
And I'll reserve my objection. Thank you.
Hold on. Just look through it.
No. No, this is different from the language of the policy, so no, I'm not familiar with this.
You're not familiar with this document. You've never seen this.
No, I have not.
All right, then the district will understand it's not yet admitted.
So members of the panel, just disregard for now. It's District Exhibit 6.
You okay with them keeping them? We can,
They have it turned over.
yeah. I think they put them in their book, though. Okay, all
If you could just, I think you just did, but
I
instruct
did.
them that not to rely on it at this point.
Yes,
Thank
just
you.
don't consider
Okay.
Exhibit 6L. It may become admitted later, but as of for now, just do not consider it School District Exhibit 6.
And Ms. Rinderly, if you'll turn to Exhibit 7. Can you identify this document for us?
No,
You're not familiar with this document?
I am not.
Okay. Then the district will not offer that yet in evidence. So just to make sure I'm clear, Ms. Kale never instructed you on the process for acquiring supplemental instructional resources and getting those resources approved?
No, I never had adequate training. We did go over the language of the policies, and no.
And you never submitted a formal request for this book to be approved as a supplemental resource, did you?
I did not.
Your reading My Shadow is Purple was not the first time that your principal had to talk to you about your choice of supplemental resources in the classroom, was it?
That is incorrect.
She has never had to talk to you about your choice of supplemental resources before?
No.
Okay.
She,
In January of 2022, you read the book Stacy's Extraordinary Words that was authored by then candidate
Your
for
Honor.
governor.
Objection, Your Honor. I'm going to impose an objection at this point. This is from the 2021-22 school year. The parent tribunal knows that's from a prior contract year. Ms. Rinderly was issued a contract at the end of January, at the end of the 21-22 school year, and she was fully evaluated and had no negative comments. It is inappropriate and, in fact, illegal to go back to prior contract years to solicit evidence regarding these events and to support the charges. We'd ask that any references to prior contract years be inadmissible and not referenced. There's no pattern of conduct. There's just simply no basis that's been established to be able to use this information.
Ms. Colvis, what's your position?
Your Honor, we disagree. This is being used to show just that. There is a pattern of conduct. It's also used to show that she's been adequately trained and understood that what she was doing was prohibited by the school district.
The case of Mulder in the Court of Appeals expressly prohibits going back to prior contract years. If they wanted to terminate Ms. Rinderly for something that happened in 2021-22, they would have done it then. They didn't even note it in their evaluation or give her any kind of discipline or even remark on it whatsoever. This is the exact harm that Mulder addresses. The cases of Mulder and Peterson prevent districts from trying to recreate history in tribunal tribunal hearings. The Fair Dismissal Act has the protections of that. We ask that this tribunal and that this hearing officer in this tribunal not undermine the protections of the Fair Dismissal Act as has been expressed in the case of Mulder and the cases of Peterson.
Ms. Colvis?
Your Honor, the school district is not terminating her for a one-time reading of the book in a previous school year. They're terminating her for what she did this year, which included a continued pattern of conduct. Disregarding previous warnings in this book is needed in order to demonstrate that.
All right. I'm going to take that matter under advisement for just a few minutes. I'll let you ask you to move on, and I'll reserve ruling on that issue.
And if you'll, could I just have 1 minute?
Yes.
Break, okay.
And let me just inquire, are there other pieces of evidence, are there other things that might be brought up that also extend back beyond the current school year?
But to do with different, isolated incidents. They try to take patchwork isolated incidents, doesn't make a pattern. I have the cases, Mulder and Peterson, Brown, King, Mulders, Georgia, 267, Georgia Act 339, which establishes this principle clearly. It's, you know it is, Mr. Hearing Officer, that this has been one of the protections of the Fair Dismissal Act that has lasted over decades. The case of Mulder was decided in 2004.
What was the site, Mr. Goodmark?
2004.
I mean, what was the site of the case?
Oh, site, I apologize, 267, Georgia App 339.
What came, I was not listening to you.
Not listening.
Your Honor, may I respond?
Yes, absolutely.
Mr. Goodmark cited you to a 2004 case. I'd like to call your attention to a 2013 case called King versus Worth County Board of Education. The site is 324 Georgia App 208, pages 211 to 212. It stands for the principle that evidence from a previous contract year is admissible if it is relevant to show that the violation, which is alleged to have occurred during the current contract year, was part of a pattern of actionable conduct.
Same proposition as Mulder. It's nothing new. You have to establish that there's some pattern, not isolated, unrelated incidents. It just simply isn't a pattern. It's not been established, and that's the protections that the Fair Dismissal Act gives this educator so that we can have a fair proceeding.
All right, I'll tell you what we're going to do. Let's, since we've been going now, just a little right at 2 hours, why don't we stand in recess until 11:15? I'll take a look at these cases, and then we'll give you a
Thank you, sir.
So we'll stand in recess until 11:15.
principal asked to see the book. She read the book and said that there was something wrong with the book, and she went on to handle any kind of, I guess, emails. There were 2 emails, and I never interacted with those parents on the book. She did forward the emails to me afterwards just so I was made aware, saying that they had not yet read the book, but yes, that they did believe that any book by Stacey Abrams would be considered divisive.
Okay, and that was all back in 2022, correct?
Yes.
Okay. And your principal warned you about your choices of supplemental resources and not doing anything in class that could make it appear that you were partisan, didn't she?
That is incorrect. My principal read the book, said that there was something wrong with the book, and then said that she would respond to the parents. And it was never told to me that I could never read that book again. There was no directive with that in my.
And we're back in 2023 now, after having read My Shadow is Purple. When your principal found out that you had read and conducted the lesson My Shadow is Purple with your class, she called you down to her office, didn't she?
That is correct.
Okay. And during that conversation, you informed her that you had students doing service projects on LGBTQ advocacy, didn't you?
I did. I let her know that week of my return from Athens that my students did a conference on the topics that they had chosen, and I asked about I had one student in 5th grade that chose that topic, and she stated, she wasn't aware of that. I had told her about that, and I was going to email the parents that week. I had just returned back from Athens as well. Okay. My concern was that, I guess, informing her of this. Let's just she knew that was also a topic in class the student was interested in researching.
But prior to your principal calling you down to the office to talk about My Shadow is Purple, you had not asked permission from your principal to work with your students on LGBTQ plus advocacy, have you?
Again, I was not working with my students on this. My students are able to, it's a student-led service project where they choose a topic and then they are allowed to do independent research on the topic. Before we moved into the actual planning of the section of our service learning, that's when I conferenced with students and that topic was shared. And it was the same week that all of this happened.
All that happened before March 8th, though, isn't that correct?
No, I was informed on March 8th. Actually, that's when I had a conference with the student.
Okay. Oh, so the same day that you read My Shadow is Purple is the same day that you worked with a student on their topic of LGBTQ plus advocacy?
No, I said that's the day that the student conferenced with me to share the topic that they had been selecting through the previous week.
You had not previously notified the parents or gotten their permission for their children to be doing a service learning project on LGBTQ plus advocacy, had you?
Again, all of my students, I was informed that week of my students that they had chosen, and I was planning to, yes, contact the parents to make sure that they were aware of this as well. So, again, that all happened that week.
But your principal had to instruct you to notify those parents, didn't she?
I told my principal about this and had already planned on doing this, and my principal restated that I needed to do this.
Just so there's no misunderstanding, because I don't know that we're always communicating perfectly. Had you or had you not told the parents before you were called down to your principal's office that you had students in your class who were going to do a project on LGBTQ plus advocacy?
I had not yet informed the parents of this, no.
Okay, thank you. No objection.
All right, so it's District Exhibit 8 is admitted without objection.
Are you on Exhibit 8, Ms. Rinderly?
Yes.
You received an email on March 10th from a parent of a student in your 5th grade target class upset because you had read and conducted the lesson on My Shadow is Purple, didn't you?
That is correct.
And this parent was upset and told you that your actions had put her child in a very awkward situation, which forced her to have a conversation in her house that her family was not ready to have with him, didn't she?
That is what the email says, yes.
You never apologized to that parent or acknowledged her perspective, did you?
This email was sent on the 10th, and it was actually right before I had gone to my meeting with my principal, which this email was discussed beforehand, even though I had not read this until my lunch period. And I had been made aware that it had already been made, I guess, gone to the district level. So I always respond to parents, not sure what I could say to this. And so I did want her to know that I saw her message as well, and I did respond to it. I was not told I needed to apologize, but it was my understanding that this was already being handled outside of me. So I acknowledge that I received her email.
Well, let's have you read for the tribunal your response to this parent's upset email.
Right, so in response to the parent saying that she's not sure what would have made me choose anything. Can I read her email first?
Sure, I'd be happy for you to read her email, but read the whole thing, please.
Okay. Ms. Rinderly, I'm trying to understand why a book that fits into the genre below was an option for a read-aloud book in your class. As an ELA teacher in the county, I know that we were given explicit instructions at the beginning of the year as to what topics could be considered divisive and should not be alluded to in a classroom setting. I would consider anything in the genre of LGBT and queer as divisive. As a teacher in a middle school setting where gender identity is a topic of discussion among the student body, the teachers leave that discussion to be had in the home. We respect that our student body has differing views on this topic, and we do not feel a desire or need to have that conversation in our classroom. While I know we have differing personal and political views, I would ask that your professional instruction remain neutral moving forward. And within the Georgia standards, just as I have to within my own classroom. Moving forward, I would ask that you seek guidance from your CCC when selecting reading material to support your curriculum. If your CCC cannot reach an agreement, I trust that you would then seek guidance from your administration. Now that I have given you my professional opinion, I will tell you my personal opinion. I am very disappointed that you allowed this in your classroom. You have known my child since 2nd grade, and I have put my trust in you to challenge him academically. You allowed him to be placed in a very awkward situation, which in return forced a conversation in our household that we were not ready to have with him. I trust that you'll be more mindful in the coming weeks. Thank you, Casey Lee.
And read for the tribunal your response, please.
Casey, this text, which was purchased at the school book fair, was selected from a bin of read-alouds that had not yet been read. 9 students placed their sticky note on this book, voting for it to be read. I'm unsure what you mean by political or personal views, as neither of us know that about one another, nor is that relevant. I appreciate you trusting me to challenge your child, and I trust that you will continue to trust me in doing so.
So, Ms. Rinderly, you never apologized to this parent or acknowledged her perspective, did you?
I'm not made aware that I needed to apologize in this. I still was not made aware of what was happening with this, other than that the district had been involved. Even knowing that if I should respond at all, I really had zero guidance on this from my administration, so I wanted her to know that I saw her email, but also did not know really what to say back to that.
So you needed guidance from your administration to understand, as a tenured teacher, the need to restore a relationship when you've upset a parent?
Object, form, assumes facts not in evidence.
What's your response?
I'm trying to understand what she understood in her role as a teacher.
She indicated there was some relationship that's beyond repair. This parent didn't even take the kid out of the class.
Your Honor, I think Mr. Goodmark's testifying now.
Well, I'm going to ask you if you rephrase the question, just to make
I think we're pretty clear that you didn't apologize, so we'll move on.
Object to that argument.
You never apologized.
Just for the record, let me just say, I'll sustain Mr. Goodmark's original objection.
Thank you, Your Honor. You never apologized to your principal for having selected a supplemental resource without following policy and protocols for having it approved, did you?
I selected a picture book that I read aloud. I was not, at the time, directed about it being supplemental resource. I was told that it was divisive in nature, and I asked how it was divisive. I asked questions. Why was I apologizing?
You never apologized to your principal for not giving parents advance notice and the opportunity to opt out of this, did you?
Object. I'm going to object to relevancy. That's not a policy. There's no directives about apologies. Is there a relevancy to this?
Your Honor, the school district,
One at a time, one at a time.
the school district has lost confidence in her, and part of that is her refusal to understand and acknowledge what she's done.
I'm going to overrule the objection. Witness can answer it.
I was never made aware of really what I had done, and when I asked questions, they were not answered. So still seeking that information to know what I would be apologizing for, this was kind of shocking to me, as I'm sure you can imagine. So, yeah.
You maintain to this day your position that reading this book in your class was appropriate, don't you?
This book is about inclusion and...
Your Honor, may I ask her to answer the question?
Yeah, Mr. Rinderly, again, answer the question to the extent you can with a yes or no. Then if you need to explain the answer, then feel free to explain.
Yes, I believe it to be appropriate.
And if you need an explanation, and I don't mean to cut you off, you feel free to explain your answer.
We have no further questions at this time.
Good morning.
Reserving my direct during our case in chief, I'll ask a few very targeted questions. Issues have been raised.
We'll let you do a limited direct.
Limited direct, yes. We've been here a while, so I'm going to ask you to think back a couple hours. You were asked about hot button topics and whether or not you had previewed hot button topics with parents. Do you acknowledge that slavery in the South is a hot button topic? She was asked about hot button topics and her communication with parents and controversial issues.
Yeah, I'm going to allow it. I'm going to overrule the objection.
You acknowledge that slavery in the South is a hot button topic?
Yes.
Have you ever had to get a pre-approval to discuss Civil War history?
No, as a fourth grade teacher, that was part of my curriculum.
Does the history books prevent parents from talking about slavery in their homes?
No.
You were asked quite a bit about pre-approvals under the policy, and I'll ask you to look at Exhibit 3. It's Exhibit 2, I apologize. You were asked about informing parents of your intended or potential use. Have you ever been asked to do that in a read aloud?
No.
Under the policy, and I'll ask you to turn to page 5 of IFAA-R. When you look at the D, strike that, the C2 permissions, have you ever been trained on what the scope of those permissions require?
No.
Have you ever been trained on these terms in here, sensitive? Have you ever been trained on the definition of what a sensitive topic is?
No.
Has there ever been given examples of sensitive topics?
No, nothing other than the policy language.
And when you look at the policy itself, the supplemental learning resource, is it a requirement that you get permission?
No, it says may require,
What does that mean to you?
that based on your judgment, that you might need to receive permission.
You were asked about this book. I'm going to ask you to look at the book. You were asked about the book and whether or not it referred to the gender norm, right? If there was anywhere in this book that presented both sides of the issue.
Mr. Goodmark, just for the record, the book is District Exhibit 1, is that what we're
Exhibit
referring?
1, yes, I apologize.
Right.
Turn to the very first page of the book. What color is the dad's shadow?
It is blue.
What color is the mom's shadow?
It is pink.
What's the dad wearing?
Dad is wearing pants and suspenders.
What's the mom? What kind of shoes are the mom?
She's wearing high heels.
The mom's hair, is she cropped short, buzz cut?
She has long hair.
Long hair. On page 2 of this book, the child says there's only those choices, 2 or 1. Did you present both sides of the issue in this book?
Yes.
As an educator in Cobb County, have you presented books that follow the gender norm?
Yes.
Books with boys and girls?
Yes.
You have. I understand. Thank you. You were presented a policy, IKB-R, and in that policy, well, let's before we get to that, turn to page 2 of that policy, IKB-R. It's exhibit what?
That's 4.
Page 2 of that policy, if you look at the bottom, third from the very bottom, when was the last date that this policy was revised?
It was revised on 7/1/22.
July 1st, 2022. That was the beginning of this school year, right?
Yes.
In July. And as your training that you were asked about, when did that happen?
It also happened in July.
Probably it was before school, right?
Yes.
So probably a couple of
Mid-July.
weeks. A couple of weeks after this policy was revised.
Yes.
Were you ever trained on what a political or partisan issue is?
No.
Was there any explanations ever given to you about what those consist of?
No.
Any
Just the language.
limitations of that?
No.
Going back to IFAA-R. On page 3.
That's District Exhibit 2, Mr. Goodmark.
Yes, thank you. In here, the first part 2A, it says supplemental learning resources or any medium print, non-print designed to supplement core learning resources purchased at the district or local school level. Right? Did the district buy this book for your read aloud bin?
No.
Did the school buy this book for the read aloud bin?
No.
You were asked about whether or not you were trained on what is sensitive. And you gave an explanation that the training read the policy. When they read the policy, did your principal take time to go over the topics that would be considered sensitive?
No.
Did they give you any limitations as to what would be a sensitive topic?
No.
Did they give you any examples of what would be a sensitive topic?
No.
You were asked about what's controversial. Again, any direction as to what controversial would mean?
No.
Did you have a clear understanding of how this policy would be implemented in July of 2022 after you were trained?
No.
You were asked about these student-led service projects, but the tribunal doesn't know what those are. Can you explain what the student-led service project is and how it relates to the gifted curriculum?
Sure. So that is our unit that students were doing this spring, 5th grade and 4th grade students, and it is a student-led service project. So students were able to select a topic of research, and then they were able to choose how they wanted to implement their research project. And so we were in the beginning stages of this.
As part of choosing those topics, where were you in this process as of March 8th?
The beginning stages, so they were just selecting, different issues that they were concerned about and wanting to focus on for their continued research and then to go into the planning stage of this.
Did you know what the students' topics were weeks before this?
No, we have not conferenced yet, so they had not solidified if they were going to be working in a group or having an independent project.
Okay. And in the choice of these topics, had you had any did you give them like a array of topics to choose from?
No, it's student choice.
So no limitations?
No. It's things that they are, that they matter to them.
How long was it from the time that you found out that your student was proposing an LGBTQ topic to the time that your principal had called you down?
2 days.
And in that time, did you develop a plan on what to do?
I was catching up coming back from Athens, so yes, I was going to reach out to the parents over the weekend, catching up on all my emails and my work. So I had planned to communicate that, and then all of this kind of happened.
And why hadn't you done it earlier again?
I was still catching up from being out of town since Sunday before, and I meet a different grade level every day, so.
You referenced a tweet about the book. And this is Educator Exhibit 1.
We've seen. Ms. Coles, do you have any objections to Educator Exhibit 1? No, Your Honor. Okay, it's admitted without objection.
When you were questioned by the district, you mentioned that you had tweeted about this book last year. Is this the tweet?
Yes.
Okay, and this is admitted as Educators Exhibit 1. What was your description of the book on the tweet? You have it?
I don't know. Sorry. We read at Stacey Abrams' new book on Friday afternoon, and it was magnificent. Powerful lesson of the power of perseverance tied together with our favorite enriching vocabulary. 10 out of 10.
So what were the concepts that you were promoting in that tweet?
Enriching vocabulary.
In that whole tweet, is there any political statements made?
Oh, and power of perseverance, sorry. No.
Is that the only book you tweeted about?
No, I always tweet about books that we read throughout the year, so
And using social media, is that something that you generally do?
yes. I communicate with parents and other stakeholders in the community through my social media for Twitter and our Instagram.
You were asked about the complaints of the parents. Were those complaints lodged to you?
No. My principal.
And when you had an interaction about the complaints, what was your understanding of how it would be managed?
That my principal is going to handle it, respond to it. But she wasn't concerned with me, so I was not brought into that.
And what did she say to you about it?
This is a great book. She read the book this is a great book, and then said she would handle it.
Okay, we don't have anything further for her. We reserve our direct for our case in chief.
All right. Ms. Calvis, you have anything on recross? All right, you want to call your next witness? Ms. Rinderly, you may step down.
Your Honor, the school district calls Chris Dowd.
What's the last name, Ms. Calvis?
D-O-W-D.
Mr. Dowd, if you'll just remain standing there, the court reporter is going to raise your right hand, the court reporter is going to administer you an oath, and then be seated.
Yes, sir.
Do you solemnly swear and affirm the testimony you will provide in this matter today will be the truth, whole truth, and nothing but the truth, so help you?
Yes, ma'am.
Thank you.
Mr. Dowd, if you will, just be seated. State your name for the record, and then Ms. Culvis and Mr. Goodmark have some questions for you.
My name is Christopher Dowd, D-O-W-D.
All right, good morning, Mr. Dowd. My name is Sherry Culvis. I represent the Cobb County School District. I'm going to ask you some questions today. Can you share with the tribunal your position with the school district?
I am the executive director of employee relations and evaluations for the school district.
How long have you worked for the school district?
I've been working with the school district since 2012.
And in your role as the director of employee relations and evaluations, what do you do for the district?
In my role, I oversee the Office of Employee Relations, I oversee the Office of Evaluations, and I'm responsible for the background badges and fingerprint office.
I won't ask you any questions about fingerprinting today. With respect to employee relations and that office, can you describe what that department does?
In general, the Office of Employee Relations will handle district-level personnel matters, so that may include employee grievances, discrimination complaints, Title IX investigations, investigations into personal policy violations. We're responsible for the contractual non-renewal process. We're responsible for implementing employee discipline throughout the district. That does include something like today's Fair Dismissal Act hearing. We're also responsible for reviewing some personnel policy, making updates to personnel policy, and doing some local administration training in employee relations matters or issues.
And with respect to Catherine Rinderly, what was your role in the investigation process?
With Ms. Rinderly's case, the role I played is I oversaw the investigation, which was assigned out primarily to Robert Reinierson. I believe I also took part in Ms. Rinderly's first interview with employee relations, and I also conducted her disciplinary conference.
How did the Employee Relations Department receive notice that Ms. Rinderly had read and conducted a lesson on My Shadow is Purple?
I believe I was notified by a phone call from my direct supervisor, who's the CHRO of the school district.
Okay, and what did you do in response to this allegation?
I believe I instructed Mr. Reinierson to reach out to Due West Elementary School and to follow up and see if our assistance was needed.
Prior to your department going out to the school and officially investigating, did your department give any guidance to the principal on investigative steps to take?
Yeah, I'm sure we probably gave some guidance as to performing a local level kind of review of the situation. That probably would include interviewing students that may have been involved. That would include interviewing the employee as well, or asking them to provide a written statement.
I'm going to ask you to turn to School District Exhibit 9. Are you familiar with the School District Exhibit 9?
Yes, ma'am.
And did the district receive this statement in the course of its investigation?
Yes, ma'am.
Did this statement influence the district's handling and next steps in the matter?
Yes, ma'am.
Your Honor, we move to admit District Exhibit 9 into evidence.
Objection, Your Honor. Pure hearsay, not a court statement made by a declarant that isn't here, isn't available to be cross-examined. The foundation hasn't been laid for this statement to come in properly. Even if the statement was relied upon by the district, that doesn't eliminate its hearsay qualities. I understand that in administrative hearings, hearsay can be used at some level, but it can't be relied upon. And in this fashion, it's completely inappropriate. There's no veracity here. There's no, strike that. There's no indices of credibility on this statement. It's just simply, somebody said something away from here that can't be cross-examined by my client, and therefore it's inappropriate.
Ms. Colvis?
As Mr. Goodmark correctly identified, hearsay is admissible in fair dismissal hearings, more so than it is, of course, in federal or superior court. The district is not relying on this for the truth of the matter asserted, but to show the course of conduct and to ask Mr. Dowd the district's reactions to what it's learning here and what it did next, how it influenced their investigation and their proceeding with termination recommendations.
And, if I may, Your Honor, Finch versus Caldwell, 155 Georgia App 813. Even if I didn't even object, hearsay has no probative value. In this case, the value of this, the dangers here of the tribunal drawing assumptions from this out-of-court statement far outweigh any probative value that it may have. I have a hearing brief on the issue for you.
May I have a copy of that too, please? Thank you so much.
Just because you can have hearsay in these hearings doesn't mean you should. And certainly hearsay can't be the only evidence that the tribunal can rely upon, and therefore the dangers of allowing these out-of-court statements, and we believe there will be a few today, several even, because the district understands, as you guys could probably understand, the only people in that classroom were Katie and those kids. You can't prove it that way. You have to show direct evidence that there was a violation of policies, and the district's limited here. We don't have any notice that they're bringing these people forward. We would object to the use of hearsay in this fashion, or the fact that it would be relied upon exclusively by the district in order to sustain the charges.
Ms. Colvis, I'll give you the last word on.
The district is not relying exclusively on this. It is very well settled. Dozens of state board cases allow hearsay for the purpose of coursing conduct. I appreciate Mr. Goodmark looking for the platform to make the comments he just did, but this is admissible.
Give me just a minute to read through this exhibit.
would just call for one moment. You'll give me one moment, Your Honor. I call your attention to State Rule and Regulation 160-1-3-.04, which governs the rules for school law tribunals and appeals. Paragraph 5 states the strict rules of evidence prevailing in courts of law shall not be applicable to hearings before local boards of education.
Can you just tell me from hearing from my standpoint, what is the probative value of, it's clearly hearsay, I mean, I don't think there's any
Sure.
objections there, so tell me what is the probative value of this document?
The probative value is how this influenced their investigation, what they did next, what their reaction was to it, in forming an opinion on what to charge her with.
So can't you question the witness on that without this document? I mean, do we really need the document itself without, it's clearly hearsay without, or can't you make your point without just by just simply questioning the witness without using the document?
The district would move to admit it, but if Your Honor prefers to go that route, obviously we will abide by your instruction.
All right. I'm inclined to agree that I just in my brief reading of it that I'll allow you certainly to ask questions of the witness, but I'm inclined to say that Exhibit 9 would not be admitted.
Thank you, Your Honor. Did the district receive this statement in the course of its investigation?
Yes, ma'am.
And did this statement influence the district's handling and next steps in the matter?
Yes, ma'am.
Sorry. Did you draw any concerns from your reading of this statement?
Yes, ma'am.
Okay. Can you share those concerns with the tribunal?
Yes, ma'am. Can I ask a clarifying question?
Yes.
Am I allowed to reference the document at this point or no?
You can reference it, I mean, if it's part of your answer. Sure.
Okay, thank you. Yes, after reviewing this statement that was written and turned into Ms. Kale, district had several concerns. Most notably, the student used certain language within the document that expressed strong emotion, words such as frustrated, words such as confused, words such as angry in response to this topic of gender identity and or gender fluidity being introduced into the classroom by Ms. Rinderly, and also having a lesson about it. So that was a main concern, to see how much emotion invoked from a student that he wrote this kind of statement regarding it. Other concerns we certainly had was the introduction of the topic itself, of gender identity, gender fluidity. The student in his statement also advises that Ms. Rinderly
Objection hearsay.
advised the class.
Hold on just a minute.
Objection hearsay. He was asked about the concerns. Now he's testifying to what the statement says. It's
Yeah,
inappropriate.
well, I will ask you to limit it to your, not to testify about something someone else may have told you. But just an
Correct, sir. Thank you.
investigation.
Well, didn't tell him. He didn't take the statement. It's another problem.
Okay.
Try to focus your answer on what you drew from it and your concerns from it, please.
Okay, so our concerns, I just said, was that that the subject matter was broached and a lesson was taught regarding gender identity, gender fluidity. We were also concerned that Ms. Rinderly had introduced her own personal feelings on the matter of gender identity and gender fluidity. And we were concerned how this impacted other students as well.
And I'll ask you to turn to Exhibit 10.
Yes, ma'am.
How do you recognize that?
This is a summary of findings that was produced by my investigation manager, Mr. Robert Reinierson.
Was this record made and kept in the regular course of business?
Yes, ma'am.
And does the district routinely make these records when they're headed to a hearing for a certified teacher?
Yes, ma'am.
Was this document made at or near the time of the events that it references?
Yes, ma'am.
And was this document made by a person with knowledge or information transferred by a person with knowledge who reported such knowledge in the regular course of business?
Yes, ma'am.
Your Honor, we move to admit District's Exhibit 10?
10,
10.
right. Mr. Goodmark?
Objection, Your Honor. I apologize for having to continue this, but I object. The summary of findings may be a business record, but the hearsay that is riddled in this document is not. And we have pretty clear authority that when you're going to tender a document, that all the levels of hearsay either meet the exception or determine non-hearsay. In this case, it's not just statements of fact, but it's statements of opinions and feelings by the out-of-court declarants that are included in the summary of findings, which are inappropriate. And so we would object to the summary of findings being admitted. If the district admits the summary of findings as a business record, we'd ask for an instruction that the out-of-court statements that are not cross-examinable by the educator be identified as hearsay for the tribunal and limited with an instruction by you.
Mr. Colbus?
We don't have an objection to a limiting instruction, Your Honor, and again, it's not offered for the truth, but to show the course of conduct, why the district proceeded as it did, and how it investigated and what concerns it drew from it.
All right, I'm inclined to overrule the objection on Exhibit 10 and to admit it. I will hold it for a moment. Do you need to use it? Does the panel need to see it? Because what I'd like to do is at a break just work on a limiting instruction that we can give to the panel. Is it necessary that they see it right now?
Not right now, Your Honor, no.
And I'll admit it subject to the limiting instruction that we'll discuss in just a moment.
Thank you, Your Honor.
Can you walk the tribunal through the employee relations investigation that was conducted for us? And let's just start with March 20th. What did employee relations do to investigate this matter?
On March 20th, Mr. Robert Reinierson interviewed 4 students and 1 teacher at Dowd West Elementary School.
And share with the tribunal employee relations department's reaction to the information it received from the 4 students on March 20th.
The information employee relations received, our reaction to it was that we felt that we had established, based on these student interviews, consistency among several key points. Those key points being that, in fact, the topic of gender identity, gender fluidity was discussed and a lesson occurred on that topic. We did conclude based on that Ms. Rinderly had at some point instructed the class to refer to the main character as they instead of he, as some of the characters, the students had been addressing the main character of the book. We did in fact establish that students weren't comfortable with the content that was discussed that day, and we did establish that the students felt or believed that the lesson occurred prior to specials during what should have been their math intervention time period.
Very good. And what was your reaction to the consistency of the student story? Did that have any impact on your proceedings?
Yes, ma'am. So anytime you have firsthand witnesses that are consistent in what happens, it tends to support that finding and give it more legitimacy and credibility.
Did the district interview Ms. Rinderly on March 24th?
Yes, ma'am.
You may want to move in your report to that day. Describe for the tribunal, describe the interview, what Ms. Rinderly shared, and how it impacted the investigation.
Substantively, what was shared that really impacted the investigation, first off, we were able to confirm that, in fact, the topic of gender fluidity, gender identity was introduced into the classroom by Ms. Rinderly. We were able to substantiate that the topic, that a lesson was conducted on that topic. We were able to substantiate as well that this was a supplemental resource that was not vetted, so to speak, or policy was not followed in vetting a supplemental resource. Some other takeaways from that. Again, I think Ms. Rinderly acknowledged that she did instruct the students to refer to the main character as they instead of he, if that's what they had originally said. I think there was an acknowledgement that she said the students may have been being discriminatory if they referred to him as a he. So those were the key takeaways from that part. There was a discrepancy as far as when the lesson was taught. So, Ms. Rinderly initially advised she had done it first thing in the morning. Then she advised that she did it after specials. As I said, the students we had interviewed all were pretty consistent that it happened before specials occurred, so we had a discrepancy there that we were going to need to iron out. At the time, I believe in that first meeting, Ms. Rinderly said that she did conduct it. She wasn't sure if she had paperwork for it, but she recalled, I believe, that no student could solve the problem that she put up on the whiteboard, and therefore they had a discussion about it, something to that effect.
Let me back up for a minute and just ask you a couple key questions. In your first interview with Ms. Rinderly on March 24th, would she acknowledge that the book and lesson was on gender identity?
So no, Ms. Rinderly would not acknowledge that, and that was one of the things that was concerning to the district. Clearly, the book is about gender identity, gender fluidity. It says so on the back of the book. It talks about exploring gender beyond binary. Certainly, the students understood or that it was about gender and gender identity and how someone's identifying and gender norms and what they're wearing. But Ms. Rinderly did not acknowledge that. She failed to acknowledge that. She was presenting it as something that was inclusive. And while there may have been aspects to inclusivity, the main topic and subject matter she introduced was inclusivity about gender identity, gender fluidity. So
Would Ms. Rinderly acknowledge that gender identity was a politicized issue in this community?
No, she would not admit that either.
Did Ms. Rinderly acknowledge that she had been trained on the district policies?
Yes, I believe she did.
Okay. After the March 24th interview of Ms. Rinderly, what were the next steps in the investigation?
So the next steps for us was to iron out this discrepancy between the timeline that the students had given us and the timeline that Ms. Rinderly had given us.
Okay. And what did employee relations learn from those next steps?
We had asked Ms. Kale to go ahead and pull some more students and ask them their recollection to see if they remember doing a fractions intervention on that day when they had that lesson. And Ms. Kale came back and informed us that none of the students did in fact recall doing math intervention on that day.
Okay. How did this information influence the next steps for the district?
Well, for us, that kind of increased the discrepancy that we were already working with based on the initial student interviews. So at that point, we knew we had to call Ms. Rinderly back in for a second interview to see if we couldn't kind of close that gap between the discrepancy.
And so did the district, in fact, conduct a second interview with Ms. Rinderly?
Yes, ma'am.
Okay, and what was the date of that interview?
I believe it was April 11th, 2023.
And describe for us how the discussion on April 11th went and the results of that interview.
So the April 11th interview, during the process of that, Ms. Rinderly did continue to advise that she did do the intervention time period. We asked her if she could provide any documentation of such. She said she thought maybe there was some paperwork at the local school. She also advised that maybe she had taken a picture at some point as well. We asked her if that picture would be date and time stamped. She advised that she didn't think it would be, that potentially she took it with the camera in the classroom. Her statement was different than the first time. This time she said a student actually solved the puzzle or the equation that was up there, and therefore that picture was of the student who had solved it. But we still couldn't connect how 8 students could not remember a 45-minute time period on fractions.
And describe for the tribunal your impressions of Ms. Rinderly's responsiveness to your overall interviews with her.
The district found Ms. Rinderly to be adversarial, deceptive, disingenuous. It was very difficult for us to believe that she would continue to insist the book wasn't about what the topic and about gender identity or gender fluidity. We found her not willing to take any personal accountability. It was the students for selecting the book. Well, they selected the book, so it's not my fault. It was the school's fault for having the book fair and it being part of the book fair. There was not a point where she accepted that as the teacher, she would be responsible ultimately for anything that entered that classroom. So, we had a big issue with that. During the whole course of the 2 interviews, I never heard her ask about a student. I never heard her say, hey, how are my students? How's the Due West community? Are the kids okay? Not even this was unintentional or I'm not wrong, but are the kids okay? Is everyone all right? Did I impact anyone? I don't think it ever came up. Once the concern was always very self-directed. She came in with the strategy for the interviews, and, she stuck to that.
With respect to the fractions and the pride time, was Ms. Rinderly given the opportunity to present evidence that fractions were taught on March 8th?
Yes, she was allowed to, if she had a picture or work, to submit it.
Okay, and did she present any evidence of that?
Yes, she did want it presenting a picture of a student, I believe, next to a whiteboard.
Okay, and was the whiteboard reflecting a fractions riddle?
I believe so, yes.
Okay. Was the photo, was there any way for you to tell from the photo the date or time that it was taken?
No, ma'am, it was not time or date stamped.
Based on the district's investigation, did the Employee Relations Department make any initial findings as to whether she violated district policies?
Yes, ma'am, we did.
Did the district hold a disciplinary conference with Ms. Rinderly?
Yes, ma'am, we did.
Okay, and did the district give Ms. Rinderly notice of that disciplinary conference in accordance with your policies?
Yes, ma'am.
Okay. What day did the disciplinary conference occur?
It occurred on May 5th, 2023.
Okay. And what is the purpose of a disciplinary conference?
The purpose of a disciplinary conference is simply to let the employee know that the investigation is concluded, let the employee know that we've substantiated policy violations, let the employee know what the recommendation for discipline is going to be, and advise the employee, if applicable, of any due process rights under our policy and/or the Fair Dismissal Act.
Mr. Dowd, I'm going to be asking you about District Exhibits 11 and 12.
All right, and just for the record, Mr. Goodmark, no objections to 11 or 12. All right, they're both admitted without objection.
Just for purposes of our record, can you identify what District Exhibit 11 is, please?
This was the disciplinary conference summary that
Okay.
was given to Ms. Rinderly.
And was she given this on May 5th, 2023?
Yes, ma'am.
Okay, and can you identify what District Exhibit 12 is, please? Were these attachments that were provided to her with the disciplinary conference summary?
Yes, ma'am.
Okay, and were these given to her also on May 5th, 2023?
Yes, ma'am.
Okay. Is the disciplinary conference summary document intended to be a comprehensive list of every possible rule, charge, or piece of evidence that could be used against an employee?
It is not, ma'am. That would be cited in any kind of charge letter the district produces for a Fair Dismissal Act hearing.
Okay. And did the district, in fact, draft a charge letter for today's hearing?
Yes, ma'am.
Your Honor, just as a preview of coming attractions, I have Exhibit 13, 14, and 15 for the school district, which are the district's original charge letter issued on June 6th, an amended charge letter issued on June 14th, and a second amended charge letter issued on July 18th. Unless you disagree with me, the only differences between those second and first amended charge letters are as to the date and time of the hearing. Substantively, they are otherwise the same. We will, for purposes of the record, move to introduce all three of them to demonstrate that notice was given for this hearing, not, again, for the truth of the matter asserted in the charges, but to demonstrate that the district put Ms. Rinderly on notice of the charges and that her due process rights were followed in this matter.
That's 13, 14, and 15.
Yes.
To the extent that the charge letters are used to establish notice, we don't have an objection to the date, time, and location of the hearing. We do object to notice of the charge letter, as we've raised earlier. We would also object to the admittance of a charge letter into evidence as it is filled with hearsay. It's an out-of-court statement by the superintendent as to his, obviously, what he believes to be the charges against Ms. Rinderly. We ask that it not be admitted, be made part of this record. We ask the tribunal not be permitted to rely upon that statement. It's a completely one-sided view of the world. But we do stipulate that the educator was given notice of date, time, and location, but nothing else.
With that stipulation, Ms. Culvis, is there any need to, or can we just not do these as record exhibits? I mean, so that we don't have to admit them?
My concern with that, I mean, they definitely need to be a part of the record, right? My concern with not admitting them in terms of putting them before the tribunal, and I agree, I mean, just to be clear, we're not asking the tribunal to believe just because it's in the charge letter that the district's proven their case. That's what this hearing's for, and we recognize that. But Ms. Rinderly keeps saying that she didn't understand things, that she wasn't on notice of things. There's going to be a lot of dispute here about what notice that she was given, and so we would like them to be admitted into evidence, but we will.
All right. I will admit them. I'm going to, again, go and give you another limiting instruction on that as well, because I'm going to admit them, but for a limited purpose. So I'm going to ask that, again, we hold them. We're going to work on a couple of limit instructions now. So before we tender them or publish them to the panel members, we'll talk about that at a break. But I will admit them for that limited purposes of show and notice, which have been stipulated to anyway.
And just for the record, I'm not going to ask questions about how these were mailed because Mr. Goodmark has stipulated that she received them and notice was received.
Okay. We'll just leave them all here. Yeah, not until we do the limiting instruction. So if you don't know. Unless you need them during your examination. If you do, then we'll take a break now.
When was this hearing first intended to be held?
June 20th, ma'am.
And when was Ms. Rinderly first given notice of the charges? in the original charge letter.
The mailing date is June 6, 2023.
And I think we've already got on record that there's no substantive difference between any of the charge letters other than the date and time of the hearing. And Ms. Rinderly stipulates that she was given proper notice of the date and time of the hearing. Can you review for the tribunal the reasons the district's recommending that Ms. Rinderly's employment contract, well, actually, one moment for me, please. Craig, do you want to maybe?
All right, we're going to go ahead and take a lunch break now. We're going to be in recess from now until 1 o'clock. So I'll ask panel members if you can just report back at 1. Witness, you'll be excused until 1 o'clock. Just come back and we'll get started again for the afternoon.
Your Honor, perhaps a reminder on the sequestration.
Yes, and again, anybody who's a witness in this case, anybody potentially who's been testified or called to testify as a witness, make sure that you remain outside the courtroom at all times until such time as you've been called, and don't discuss the case with anyone else who may also be a witness, and don't watch any live feeds or anything else that might give you any information about this case.
Does the district have an opinion on that decision-making?
Yes, ma'am. We do believe that at some point, if it was known this was going to be used as a supplemental resource, that she should have sought out an appropriate approval for using the book, either with her principal or if she thought this may come up, some kind of advance notice to parents that this topic is in my classroom and may at some point come up.
Did Ms. Rinderly tell investigators that she thought she was allowed to read the book because it was for sale at the book fair?
Yes, ma'am, she did.
Does Ms. Rinderly's claim that she thought the book was permissible because it was at the book fair change your position on this matter at all?
No, ma'am, it doesn't. The book fairs aren't set up as or intended to be classroom resources. They are intended for parents and students to make selections of books that these students might like or be interested in, and that the parents might like or be interested in, and purchase them.
What is the primary purpose in your understanding of a book fair?
My understanding is it's fundraising, ma'am.
And do teachers sometimes buy books for their classrooms at the book fair?
I would assume some do, yes.
Yes. And do parents buy books for their home at the book fair?
I would assume some do.
Does the school district select the books that will be sold at the book fair?
My understanding is we do not.
Okay. And does the district pre-approve the book fair books for use in the class as supplemental resources?
No, ma'am.
Is it still the responsibility of a teacher to do that, even if the book is for sale at the book fair?
Yes, ma'am, it's always the ultimate responsibility of the classroom teacher.
Did your investigation reveal whether Ms. Rinderly had been previously warned about using supplemental resources in a way that could be politically polarizing to her students or her parents?
Yes, during the course of the investigation, we were made aware that I believe approximately a year ago, Ms. Rinderly was or had been spoken to by her principal about the use of a book in her classroom that was tied into or authored by at that time, a current political candidate for office. I believe that principal did receive some complaints at that time. The principal reviewed the subject matter, didn't have a problem with the content, but she did have a problem, and rightfully so, that the book could be viewed as politicized or be controversial just in the fact that she tagged an active candidate for office.
And what is the importance to you on the impact of that history? The district's not terminating her for reading that book a year ago.
No, ma'am. What the district does when we look at that, it shows that Ms. Rinderly had a prior discussion concerning something extraordinarily similar in nature, supplemental resource, using that resource in class. Resource was not approved or vetted. And so we feel like just the fact that she had that conversation, a red flag in anyone's mind should go off. Oh, hey, we kind of talked about this. Let me at least make sure this is okay. Let me make sure this content is something that's acceptable, because I know I've kind of had an issue like this before.
Do you have any closing remarks about why the district is recommending Ms. Rinderly's termination?
We're recommending Ms. Rinderly's termination, based on totality of circumstance. I mean, primarily, it is on the introduction of, controversial, political, sensitive subject matter, especially to the age group or the education level that it was introduced to. But certainly there were secondary issues. Certainly there were issues, I would say, regarding subordination. So the fact that she had been priorly told and kind of disregarded or forgot what she had been told regarding another supplemental resource issue. Certainly we feel that she was trained appropriately Well, I know this has been a focus for the district. I believe at the beginning of the year, she was trained in supplemental resources and controversial issues. I even believe the Parents' Bill of Rights has been trained fairly recently. So I believe something occurred at the beginning of 22, 23, and then again just this January, if I'm not mistaken. So we do feel she had this prior training as well, still disregarded it. We had problems with her honesty and cooperation in the investigation. We still have issues with her just denying the basic premise of the book and kind of standing by that. Like, I'm not going to come off that this is inclusivity. We don't find her coachable. This was not an employee that we thought, oh, okay, she's going to learn from this, she's going to improve. She came across as one who's adversarial, even in the meetings. It's just point this out in the policy where it is. The kids selected it. It was in the book fair. There was never a sense of, okay, let me maybe reflect, and maybe I do own some accountability with this.
Thank you. No further questions at this time?
Mr. Goodmark, you have anything on cross?
Yes, thank you. And you said a couple times that you based your decision on the fact that Ms. Rinderly was adversarial and wouldn't accept your view of what had happened. Is that right?
I don't think I said that, no.
Okay, well, she's allowed to state her position, isn't she?
Yes, sir, she is.
And she's allowed to defend herself, isn't she?
She is.
And she's allowed to tell you if she disagrees with your characterization of the events that she's been accused of, correct?
Correct. She's free to present her side of the story.
In fact, in your testimony, you yourself admitted that this book is about inclusiveness. You testified. You said, oh, I'll meet you halfway. I see it. It's about inclusiveness. And isn't that what Ms. Rinderly was telling you?
Yes, she was trying to tell me that.
But you called that adversarial and inappropriate and grounds for termination. You said you based your opinion about termination on the fact that Ms. Rinderly had been talked about a prior incident in 2022. Would your opinion change if that was untrue and she hadn't been talked to about that?
I don't know if it would or wouldn't.
Okay, so you can't tell me as an investigator and somebody who's an executive in the HR department if your opinion changes if you fact change. You can't tell me that?
It would depend on the facts and circumstances, sir.
The facts have changed now. You said that she was told about something. And if that fact changes, she was not told about that. Would that change your conclusion of whether or not there was a pattern of conduct?
Your Honor, I object to posing a fact that's not in evidence, that's hypothetical.
You're allowed to answer the hypothetical.
Yeah, he's got him on cross-examination. I'll allow him to ask the question, if he can answer it.
You want me to speculate on what again?
If your opinion would change. I'm not asking you to speculate. You're a professional. You are charged with making these recommendations.
Yeah, does,
He always heard the same respect we've given Ms. Rinderly.
That's
yeah,
fair.
sustained.
I'm not asking you to
Don't be objecting.
speculate, just asking you to answer the question. Assume now that the facts are changed, that she wasn't told about the Stacey Abrams book and she wasn't given any directive from her principal. That would change your opinion, wouldn't it?
It would slightly impact the opinion.
It would change it in a way that would be in Ms. Rinderly's favor, correct?
It may.
I mean, you yourself in the investigation said, hey, if you show us evidence of this stuff, then we'll take that into consideration. If you prove you did a math lesson, well, then you did a math lesson, right?
Correct. We offered her that opportunity.
Right. And in fact, she met you at that offer and she proved she did a math lesson, didn't she?
I don't believe she did, no.
May I ask you
Let Ms. Coates.
to the tribunal, please?
before you publish those, Mr. Goodmark, let us, or you can just leave it here if you want, that's fine.
Your Honor, the district has a version of this that has the student's picture redacted.
Oh, sorry.
We would request that that version be used.
Fine.
Yeah, that'll be fine.
Okay. Has it been disseminated?
No, it has not.
And do you want it exactly?
I just want the official record to reflect.
Yeah, do you have any objections to us? Go ahead, we can go ahead and question the witness using this document. We'll just substitute the redacted version. And this is Exhibit 2. Am I right, Mr. Goodmark?
Correct. This is Educator Exhibit 2. In the course of your investigation, did you see this picture?
Yes, sir.
And did you make this part of your investigation notes? Or make this part of the investigation file?
I believe so, sir.
Are you responsible for producing that investigation file when educators ask for it?
I'm not personally responsible for it.
Do you have any explanation why that picture wouldn't be in the investigation file when Ms. Rinderly asked for it?
I do not.
Should have been, right?
I would agree.
This picture depicts a student in front of a whiteboard, correct?
Yes.
I'm going to show you a blown-up picture of it that faces them. It doesn't face anybody else. This is just a blown-up version of the picture so that we can see what's on the whiteboard. This is a whiteboard, isn't it?
Correct.
And at the top of this whiteboard, it says fraction riddle, correct?
Yes, sir.
And on the whiteboard, it contains digits 1 through 9, correct?
Mr. Goodmark, is that just same thing? Just, yeah, turn it that more, and you can take it over there closer to the witness if you want. So the only really people that need to see it are those people over there, so, perfect. Thank you.
Contains digits 1 through 9, correct?
Yes.
And then this is a redacted version, so actually, this is the one.
No, yeah. Yeah, but
Unbelievable.
let's substitute, if you will, just show it. This is not going to be an actual exhibit. You're just using this for demonstrative purposes, right? So just keep it up there and keep it facing just the panel members and the witness.
Right. And this has in the bottom 2 lines of this picture, there are fractions in the formula that you see there, correct?
Yes.
And there are 2, and they both have a fraction there. And on the student's board that he's holding, what is he holding there in his hand?
He's holding a board.
He's holding a whiteboard as well. And on that whiteboard, you see fractions on that whiteboard, don't you?
Yes.
And in fact, during the investigation, Katie Rinderly told you that she had done a fraction riddle on March 8th, didn't she?
She said she believes she may have, yes.
Okay. And then she handed you evidence of that to
Well-
verify that she actually did a fraction riddle, didn't she?
She did a fraction riddle, correct, which is not pride time, which is not a 45-minute block of intervention. So you're trying to make out what may have occurred as one riddle for maybe one student. I don't know, because 8 students couldn't even recall doing it. Couldn't recall a 45-minute block. They couldn't recall it. But you're presenting one picture.
8 students is interesting. Let me ask you about that. You testified that there were 8 students interviewed. Can you turn to exhibit? Exhibit 10 that's in front of you. This is the summary of findings. This contains the interviews and the evidence that was collected in the investigation, correct?
Correct.
If there was evidence about the investigation or evidence about Ms. Rinderly's actions, they would be in this summary of findings, correct?
Yes, regarding her actions, correct.
You just testified there are 8 students that were interviewed. There are only 4 students in the summary of findings, correct?
Correct. They were the initial students interviewed.
The summary of findings you just testified would contain the interviews of the students, would contain the evidence that you collected. There are 4 students' statements that are not in the summary of findings, correct?
An additional 4 students were interviewed by Ms. Kale, yes.
But I'm asking you, you have just testified that there are 8 students interviewed, but there are only 4 students in the summary of findings, correct?
There were only 4 interviewed by employee relations.
That is different than what you testified, isn't it? You have changed your story now. You have said there were 8 students interviewed, and then you said that all of the interviews would be in the summary of findings. But they're not here, are they?
Repeat that?
Are all 8 students' interviews in this summary of findings?
No, Ms. Kale interviewed 4 of them.
I asked you if that evidence would be in the summary of findings, and you said any evidence about Ms. Rinderly's actions would be in the summary of findings. Now you're testifying that there are 4 student interviews that are not in the summary of findings, correct?
And yes, I'm testifying that the ones Ms. Kale did are not in here, correct.
The ones that are in here are the basis that you claim caused you to have concerns about Ms. Rinderly's honesty, correct?
I said we had a discrepancy, yes.
Discrepancy, I'll say.
Your Honor, could we avoid the
Mr. Goodmark, no.
commentary?
Yeah, no commentary, Mr. Goodmark. Ask questions, the witness.
Well, let me ask you, and I know it's redacted. All the students that were interviewed were boys, isn't that correct? If
I
you,
believe of the 4 original, yes.
all the students in the summaries of findings were boys, correct? All the students that were entered in the summary of findings were white, correct?
I have no idea the race of the students.
Because you didn't conduct those interviews?
No, sir, I didn't.
These interviews were done 12 days after the March 8th lesson, correct? States they were done on March 20th,
Correct.
and that's almost 2 school weeks, maybe even 3 school weeks after the fact, correct?
Be about 2 weeks, correct.
When you interviewed Ms. Rinderly about what happened, that was 5 days after, correct?
When I interviewed Ms. Rinderly, I
When Ms.
interviewed
Rinderly, excuse me, when Ms. Rinderly
No,
was
we
interviewed.
interviewed her after the students, I believe. That was
No,
4 days, actually, after.
4 days, thank you. So 4 days for Ms. Rinderly's statement, 2 weeks-ish for the, for the,
Representing the testimony that's just been given.
oh, what did you say?
He said 4 days after Ms. Rinderly. He interviewed the students 4 days after he interviewed Ms. Rinderly.
Ms. Rinderly, I'll ask it this way, that's fine.
I sustain that objection. I think that is what he said, but you can
March
re-ask
8th,
it.
March 8th was the incident. Ms. Rinderly was interviewed March 13th, correct?
No, she was interviewed March 24th. The students were interviewed March 20th.
Ms.
The
Rinderly.
students were interviewed first by Human Resources and Robert, and then Ms. Rinderly was interviewed.
Well, Ms. Rinderly was interviewed, strike that. And when she was asked about what happened during that meeting, that you were in attendance to March 24th, and the recordings were made, did you record that meeting?
And someone in Player Relations did, correct?
Somebody recorded it. Her description, do you recall, or do you agree that her description was that they did a riddle fraction problem that morning, they had to find a working denominator, and I gave them, I think it was 2 different fractions. When they added the fractions together that day, they had to equal 1 whole. But they'd have to use the number 0 through 9. They had to use every digit in order to solve that. Do you remember that?
Not verbatim, but I believe she did mention that, as well as that no student was able to solve the riddle, so they had a discussion about it.
Mr. Goodmark, again, I'm going to instruct you not,
Again, we would have a very important continuous objection to using the face of a student that is controversial or confidential and showing it to the audience, Your Honor. We've asked for that.
this face has been redacted somewhat, but I'm still instructing you, Mr. Goodmark, not to show that to anyone other than the witness and potentially the panel. But and you can walk over there.
I have a copy of it. I have a copy right here. I can use that.
He has this photo in front of him. Let's put this away since we've had
Yes, sir.
multiple mistakes already. Again, the students should be left out of this.
Do you need the demonstrative evidence anymore? Well, he does, but he has the exhibit in front of him.
It's enlarged so that the tribunal.
The tribunal
But
has
the
the exhibit.
panel also has it. I think the panel, does the panel, we don't have it yet? Okay, all right. So move it up so that the panel can see it. And please, it hasn't been tendered at this point.
Can we just tender it and move on past the mistakes that keep happening?
You want to tender the exhibit? All right. Any objections? All right, it's admitted. Now, I'll ask you, Mr. Goodmark, if you will, just remove the demonstrative
And Your Honor,
exhibit.
just for clarity, the redacted version will be what is in.
Exactly. For the record, yeah, when Court reporter, when we get Exhibit 2, it'll be a redacted version of this Exhibit 2 that the panel currently has. It's turned around. Okay. Go ahead, Mr. Goodmark.
Do you see as she described it for you, do you see it now? The numbers 0 through 9 across the top?
Yes.
And you see the fractions being added together?
Yes.
And you see the picture of the student actually doing that.
I see him, yes.
And Ms. Rinderly told you that was the exercise that they did on March 8th, correct?
It's possible she described something similar.
Do you want me to read it for you again?
If you'd like to.
Sure. As you're looking at it, they added fractions together that day. It had to equal one whole, but they'd have to use numbers 0 through 9. They had to use every digit in order to solve it. It ended up being a 2-digit over 2-digit plus 3-digit over 3-digit to find it. Do you see the 2-digit over 2-digit on the boys' board?
Yes.
And you weighed that statement that you were given with that picture against the statements of 4 fifth graders, correct?
In simplistic terms?
Let's look at their statements. Student 1 on page 1, I believe.
Your Honor, I'm happy with this coming in, but we had a whole lot of objections about testifying as to what the student said. So
Well-
I guess all I'm saying is what's good for the goose is good for the gander.
I think he's questioning on Exhibit 10.
Exhibit
right?
10,
And
his
it's already
findings.
It's been admitted.
Okay.
So I'll allow him to ask questions
Thanks.
about it. It's a documents in evidence.
Exhibit 10 on page 1. Student 1 says, actually, turn to page 2 of that. It's still student 1's statement. 4th bullet from the end. He says they did not participate in Pride Time, parentheses, math intervention. You see that?
Yes.
Okay, and that was his statement.
Yes.
Let's turn over to what student 2 said. Student 2 on page 3 of this document says, fourth bullet from the bottom, they took a short test during pride time. So that's different than what student 1 said. They didn't
Correct.
participate in front, so those two conflict. Student 3 says, and it's the last bullet in the statement of student 3. Student 3 said, they do not do pride time. So that's different than student 2, correct? Student 2 said they did a test during pride time.
Correct. Students 3 said that they didn't have pride time that day and they don't usually do math intervention.
So they did not do pride time. That's different than student 2, correct?
Correct? Student 4 also stated they did not do pride time.
Well, that's different, isn't it? They don't have pride time is different than they don't have pride time that day, correct? One means they never do it, which is one thing you investigated and found not to be true. The other means they didn't do it that day. Those are different, aren't they?
Correct. They are different.
One of the things that you relied upon in making your recommendations about Katie Rinderly was consistency. Yet we have several inconsistencies in these student statements that were given more value than Ms. Rinderly's accurate description, verified by a picture that was given to your office.
Your Honor, I object to the characterization of it being accurate. That is for this tribunal to decide.
That's fine.
I'll sustain. You can rephrase it, though, Mr. Goodman. I'll let you ask the question. Just change the.
Do you weigh consistency of the witness statements with each other in making a determination as to whether or not they are accurate?
Yes.
Okay, and you looked at these 4 student statements, and in your professional opinion, you concluded that those were more accurate and more probative than Ms. Rinderly's statement.
Yeah, I'm 100% confident that those students did not acknowledge having a 45-minute intervention period, which is what Ms. Rinderly is supposed to be doing. So, yes, 3 students said we don't do pride time. 1 said I took an assessment.
And you have information.
No one said I did 45 minutes of fractions today, as I'm supposed to do.
And you have the students saying that they didn't do 45 minutes?
I think it's implied when they say we did not do pride time.
But it's not on the paper, is it?
It's not what?
It's not on the paper, is it?
I believe it's stored in their recorded interview.
Recorded interview. There's recorded interviews of these student statements?
I believe there are.
Well, we weren't provided those. We need to stop here.
Well, we'll have an approach, Your Honor.
Sure. So at this time, members of the panel, I'll ask you if you'll step out for just a minute. We're going to have a discussion on the record outside of your presence, and then we'll bring you back in when we're ready.
Should I step out as well?
No, you can stay. You
Okay.
can stay. All right, Mr. Goodmark, do you have anything you want the court to address?
As we stated earlier, there was clearly parts of this investigation and, documents, recordings that have not been produced to the educator. We were not aware that there were recordings of students. We were not aware that there were that many students that were interviewed. The district hasn't provided that. The district has been playing hide the ball, creating a trial by ambush, trial by surprise, in violation of the educator's rights under the Fair Dismissal Act. We don't have the opportunity to cross-examine witnesses that we didn't know existed. And that's simply what we have here. And so the district will tell you that, well, you got the 4 kids that's in the summary of findings, but we've got testimony now that there were more than that. And how do we know that those kids didn't verify Ms. Rinderly's statement? And the best evidence of that is the recordings that they took. They clearly didn't take notes, so they took the recordings. We should have the recordings. Without the recordings, the proceeding seems to me to be unfair, seems to violate the Fair Dismissal Act's rights that are conferred upon Ms. Rinderly, that she be able to cross-examine those that accuse her. So,
Ms. Colvis?
I have one moment, Your Honor.
Yes, you may. While Ms. Colvis is thinking, Mr. Goodmark, what remedy is it that you're seeking? I mean, what is it that you would ask me to do as a hearing officer at this point? Okay.
to us, the hearing is tainted, the tribunal is tainted. We'd ask that the hearing be dismissed and the educator's termination proceeding be dismissed. Short of that, we need an opportunity to review those recordings. We need an opportunity to subpoena those witnesses. We believe the tribunal could return. That's not my first inclination. I like to get this thing going and finish it up, but it's just simply not fair any other way.
All right. All right, Ms. Colvis, whenever you're ready, you can respond.
And we're looking for one other thing, but just very briefly, Your Honor. I appreciate Mr. Goodmark's advocacy, but he's misplaced on what the rights and boundaries are in this hearing, and it is well settled. There's not discovery in Fair Dismissal Act hearings. The idea that he's entitled to exculpatory evidence is pulled from criminal law. It does not apply in this hearing. He knew the contents of the summary of findings, which outlines the four witnesses who were student witnesses who were interviewed by employee relations. We will talk about the other 4 students who were interviewed by Ms. Kale when I have an opportunity for redirect. Mr. Goodmark issued Open Records Act requests to the school district. This hearing is not a venue or a jurisdiction to enforce a disagreement with compliance of the Open Records Act. If he doesn't like that, he's got another opportunity in another forum. The role of this hearing is to enforce subpoenas. Mr. Goodmark did not subpoena the investigative file in this case. He had the opportunity to do that, and he didn't do it. I think candidly we're making a bunch to do about nothing. If I could have one moment, I also believe he's got these records, but if you'll just give me one moment.
Yes, take what time you need.
This may take me a moment. Could I have just a moment to?
You may.
Your Honor, in June, a couple months ago, the school district produced the only documentation that I'm aware of that reflects the other 4 students, the subsequent 4 students, to Ms. Rinderly in response to an open records request that she had. And I'm looking at those documents. So that information was produced.
Your Honor, it was produced in redacted form. There's 4 students in the summary of findings and 4 students referenced by Ms. Kale. There's no way for us to know that there's 4 additional students. It's just simply impossible that the district has insisted on giving us these redacted records, and now we are left, again, behind the 8 ball, trial by surprise. Oh, there's 4 more kids that we talked to. We had no idea that those were 8 kids. It's simply, I mean, it's too much for one to take.
Well, again, Your Honor, the Open Records Act requires the school district to maintain the confidentiality of students, and that's what it did. And again, we're arguing about the Open Records Act in a jurisdiction that doesn't have authority over the Open Records Act.
Well, no doubt I have no authority over the Open Records Act. I think Mr. Goodmark is saying, though, that it's a due process issue almost is what I'm hearing.
Then he should have subpoenaed the information, Your Honor.
How would you know who to subpoena? The names are redacted.
Answer that question.
May I ask for the rest of the audience to maintain some decorum in that?
Yeah, if I didn't hear anything, but please, I've asked everyone in the audience to please refrain from any outbursts. So, and you've all done a great job with it, but I'll ask you again, please don't interrupt these proceedings in any way. All right, Ms. Cobbs, answer Mr. Goodmark's question, though. How would he know?
And I guess what I'd also like to say is this. The emails that were, and I guess I have a continuing statement that we are arguing about something that is not within the jurisdiction and authority of this venue. But Mr. Goodmark received copies back in June of emails that say, on March 31st, from Sissy Kale to Martha Haley, hey, spoke with redacted. Normal pride time, they would do games or like brain teasers during that time, and when done would start working on their projects. He said they did not start fractions. Next student redacted. Normal pride time day, they would do brain teasers during that time. He said they did not start fractions until the sub. He's got an email that shows that information was being collected on March 31st. That's not the day, may I finish, thank you. That's not the day that the students in the other 4 students, the initial 4 students, were interviewed, as reflected in the summary of findings, which says that on March 20th, and it relates what was discovered from the initial 4 students in the interviews conducted by employee relations. These subsequent students, as shown by the emails, were follow-up students that were probed by the school. That's why they're not in the summary of findings, and that's why there's an email that reflects what they had to say about it. There's not a secret here. It's not a trial by ambush.
All right, Mr. Goodmark, I'll give you the last word.
Thank you. Again, redacted statements from an email that was sent by Mary Kale, who in the summary of findings says is the person who interviewed the kids. Rob Reinerson met with Mary Kale to review complaints, and after speaking with the principal, we began to interview students. I mean, that's the same thing. How are we supposed to know on March 31st that those are different students? There's no way.
I guess my question to you would be, what duty does the district have to disclose that to you?
Again, that's the procedural due process requirements that come along with actually having a Fair Dismissal Act hearing.
But they're not.
This educator, sorry.
You correct me if I'm wrong, but the district is not planning to utilize those interviews of those four, or those testimonies of those 4 students, are they? Is that?
The district testified to the consistency of 8 students on this, but again, he was given notice of it, and I have to remind Mr. Goodmark, respectfully, he has subpoena power and he didn't choose to exercise it.
Who? Who would you subpoena if you don't know the names?
He could have subpoenaed the documents and had them unredacted. That's how this works. There is no right to this information ahead of time.
Okay.
We asked specifically in our Open Records Act for audio recordings. That wasn't provided. We asked specifically for exculpatory information. We asked specifically for the names of the witnesses who would have that information so that we could cross-examine it. And at every turn, the district has hidden that information, just like they hid the picture. I mean, let's not be lost on what's gone on. The picture wasn't even produced until this morning. They've had it the whole time. He just testified to that. They're hiding the ball.
May I address that for a moment? And again, talking about an Open Records Act request versus a subpoena. When this picture was subpoenaed, it was produced. Okay? By the way, the district got this picture from Ms. Rinderly. So the idea that Ms. Rinderly has been blindsided is a complete red herring. She took the picture, she sent the picture to the school district, and now she's claiming that the fact that she hasn't had the picture during an Open Records Act has somehow impacted her ability to defend this case.
Oh, no,
That's
no.
nonsense.
The picture is about the way they do business, and we'll bring that up during the hearing. You can't subpoena what you don't know exists. We've asked for audio recordings. They say there aren't any. So how are we supposed to know to subpoena those to the hearing when they've affirmatively said they've given us everything, but yet there was more? There's no way to do that. And so we've been denied the right to cross-examine that information. We don't know if what he's saying is accurate because we would have been able to listen to those recordings. If it was inconsistent with what he said, we would have brought those witnesses in. I mean, really, there's no way to unring the bell. And the tribunal is left with holding what is essentially, a trial that is headed for a very difficult end.
Just to be clear, the school district never said there were no audio recordings. The district responded to an Open Records Act and identified the statutory basis for redactions under the Open Records Act, which includes information containing student confidentiality and personally identifiable information. Student audio recordings fit squarely in that category.
All right, Mr. Goodmark, I know of no requirement, nothing that would compel the district to have disclosed those documents to you. So for that purpose, I will I'll overrule your motion or whatever it is, wherever we are procedurally. I will allow you certainly to cross-examine the witness, which you began doing, and you can certainly cross-examine him as to the other students and the students that were disclosed to you and the ones that weren't disclosed to you. But that's as far as I'm going to go at this point.
We would object to that.
Sure.
Thank you.
All right, bring the panel back in. All right, Mr. Goodmark, you may proceed with your cross-examination.
Sure. We were talking about the student's testimony and the inconsistencies that we had already identified and you confirmed. And in fact, one of the stronger statements that you made is that your recommendation for termination was that Ms. Rinderly directed the students to use they, them. I think that was what you said, right? And, correct?
That's what we're informed by the students, correct?
That's what the students informed you, and they were consistent in that, right?
Multiple students advised that, yes.
Oh, so there was an inconsistency, correct?
As far as that topic, you mentioned it, we didn't prod them with, did she say this or not, if that's what you're asking.
Well, I'll ask you to look at the summary of findings on page 2. Third bullet down. It says right there, student 1 says she did not tell the class to refer to the characters as they, them.
Where is that, sir?
Third bullet down, page 3, of the summary of findings.
Page 3. Oh, I see that, yes, correct.
Right, and so that student said she didn't do that, correct?
Correct.
And student, the student below, I'll call him student 3. Student below said she told them to refer to the character as they, them. It's they, not he, is what the summary of findings says, correct?
Correct.
So those aren't consistent, correct?
Correct.
In fact, they're exactly opposite.
Correct.
You testified that Ms. Rinderly told you that that the books were allowed because they were at the book fair. Was that what you recall?
I do recall that, yes.
She told you, let me get the transcript here. During that meeting that you were at on March 21st, she said the book fair's been around forever. I buy hundreds of dollars of books. I spend my money there. We're encouraged to go there. You remember her telling you that?
Yes, I do.
She told you that parents buy books for the classrooms. You remember her telling you that?
It's possible, I don't remember that
told you that-
conversation verbatim.
That's fine. She told you, well, I have it verbatim, so I can represent to you that the recordings say that she said, parents buy books for our classroom. You agree? She testified that, she told you that parents give us gift cards to buy books for the classroom. Do you remember her saying parents give gift cards to buy books?
I don't recall it, but it's possible.
So, and then she told you that never in her 10 years, and she graduated from Cobb County Schools, that she hadn't seen a book that hadn't already been an okay book. Do you remember that?
Again, I don't remember it, but if you're telling me that's what's written in the transcript.
Okay, and your testimony was that she said that because it was at the book fair, it was allowed. That's not what she told you. She said because it was at the book fair, she assumed that it was okay, right?
Okay.
And then she asked you a question. She said, who approves those books and looks at the list before they let somebody come onto our school and set it up for students to buy? Do you remember that?
Yes, potentially.
And you didn't like that because you wanted her to take accountability for her actions at that point, and you redirected the conversation. Do you remember?
I don't remember, but you can read it.
You testified, no, let me ask you because I have it written down, but I want to be sure. Is it your testimony that educators are responsible to get all their books pre-approved?
It's my testimony that when using supplemental resources, there's a process for that, and some would require pre-approval, yes.
Some, but not all, right?
Anything that's being introduced as a topic of subject matter and used in a whole class lesson would require that.
Pre-approval.
Yeah, it's being used in a whole class lesson.
Is that from
Yes.
policy IFAA?
I don't have it in front of me.
You do have it in front of you. I think it's exhibit, I got the exhibit. Exhibit 2. If you turn to page 3, it talks about supplemental learning resources. And if you go down to part A3, it talks about the things that aren't bought by the district or the local school in non-school materials. You see that?
Yes, I do.
You agree this is a non-school material?
Yes.
This wasn't something that was bought by the school district to be in Ms. Rinderly's class, correct?
No, the school district did not buy that from Ms. Rinderly, correct?
And it says it's the responsibility of the teacher to preview non-school materials and inquire a guest presenter's information for the contents, right?
Correct.
Doesn't say it has to have pre-approval from anybody there, does it?
Not in that section, sir. I don't believe it does.
And if you turn to the back, page 5 of the policy, supplemental learning resources preview, C2 says that the teacher, principal, or designee may require permission. You see that?
Yes.
Doesn't say that it has to require written permission, does it?
It uses may.
Uses may, which is a permissive, correct? It means that you don't have to do it. You may do.
Correct.
Okay. Jumped in here, and I wanted to make sure I understood a little bit about your background. I apologize. Again, you've heard many times Ms. Colby's tell you that we don't have discovery, so I don't even know who you are.
I doubt that.
Your first job was in Cobb County as a teacher in Wheeler High School. Is that right?
That's correct.
Who was the principal that hired you?
It's hired by Joseph Boland. Joseph Boland?
Boland, okay. And you left the district in 2005, correct?
Yes, I believe it is.
And then you took a job in the Atlanta Police Department, is that correct?
That is correct, yes.
And you were a member of the Red Dog unit of that outfit, correct?
Sure. All right, Mr. Goodmark, you may proceed.
Thank you. You were an officer in the Red Dog Unit in the City of Atlanta Police Department, correct? Your Honor,
What's the relevance of Mr. Goodmark?
Your Honor, the primary issue in this case is how sensitive or controversial are LGBTQ issues. The Red Dog Unit was cited and confirmed to have the word I keep saying is rated, excuse me, is the word they use in the transcript for the trials, rated gay nightclubs in the City of Atlanta. They were cited for civil rights violations. I am concerned that this witness may have a bias against the LGBTQ community and a bias away from LGBTQ issues. I'm just trying to explore that bias and to ensure that the tribunal can make a determination as to this witness's credibility on these issues.
I'll overrule the objection as to the issue of bias. I think it's potentially probative as to the issue of bias of the witness. So.
Thank you. As part of that outfit, you were a defendant in a lawsuit for a violation of the civil rights of citizens at a gay nightclub in Atlanta. Isn't that correct?
Yes.
He said, yeah, but he was part of the outfit. And they were. You left Atlanta Police Department in 2012 after the Red Dog Unit was eliminated, correct?
I think I continued to work for a little while, but I started in Cobb County in 2012, yes, beginning of the year, I believe.
And you were aware that the civil rights lawsuit in which you were a defendant was settled for a large sum of money for the plaintiffs, correct?
Your Honor, I object, I've got a continuing objection as to the relevancy of what happened in a separate lawsuit against a separate entity.
I sustain that objection.
That's fine. In the course of that, the city retained a former U.S. attorney to investigate the activities of the Red Dog Unit. Do you remember that investigation?
Yes, I do.
Do you remember there were allegations as to you using slurs in that investigation?
I do.
And you remember you were actually accused of using racial slurs, correct?
Yes.
And ultimately, as part of that investigation, you received written reprimands for your participation with the Red Dog Unit, correct?
I did, but I'd like to, for the record stated, it had nothing to do with discrimination or any sort of racial slur that was made, if you were trying to bring those together somehow.
That's fine. But you did receive a reprimand for your participation as the Red Dog Unit, correct?
I did for a search and seizure, yes.
Search and seizure for violating somebody's civil rights, right?
Your Honor, continuing objection.
That's fine.
How you effectuate a search and seizure as a police officer doesn't have anything to do with how you administer a personnel investigation.
Certainly it does when those persons are gay, lesbian persons.
I'll overrule it. I'll allow it. Go ahead, Mr. Goodmark.
Again, we're trying to explore whether or not there's any witnesses bias against gay and lesbian people who participated in the Red Dog Unit.
I've ruled to allow you to ask.
Oh, thank you. In 2012, then you came to Cobb County after you left the Red Dog Unit, correct?
I left the Atlanta Police Department. I left, when the Red Dog Unit was disbanded, I went to another unit in Atlanta, went to the Community-Oriented Policing Unit, and then I went to Cobb County School District.
As part of that investigation, and because you had indicated that you weren't reprimanded for that allegation, is it your recollection one strike. Can't find that's from the report itself. Where? This is from the report itself. What does that say? And do you recall reviewing the investigation when you were in part of that lawsuit?
What do you mean by reviewing the investigation?
Did you read the report the U.S. attorney had commissioned?
I've seen parts of it. I don't think I've ever read the entire.
The parts that you're referenced in, there's an allegation, quote, that exists that Walters and Dowd were in a conversation where Dowd allegedly stated that this is more fun than, and then you use the N-word on crack. And both officers laughed at the comment made. Do you recall reading that in the investigation?
Yes.
The investigation said the evidence also shows there was an African-American officer a foot away from Dowd and Walters when the comment was made, and the same comment was allegedly heard at different times and in different locations at the Eagle. Do you recall that allegation?
Yes, I think that's the same continuing part you're reading.
And then this was in 2011, and from there, you moved on to Cobb County Schools. Did you have any employer between City of Atlanta and Cobb County Schools?
No, I went right from City of Atlanta Police Department to Cobb County School District.
Did you receive any training for this position?
I have received outside training, yes.
And I apologize, so you've been in the same position for 12 years?
No, I've been promoted, I think, 3 times in the 12 years I've been here.
Again, how long have you been in the position that you're at?
Since 2020.
So in the last 3 years, how many cases of employee discipline have you handled? Not just terminations, but any discipline.
No, I know. I'm trying to, as far as the Department of Employee Relations, we've probably averaged 300 to 350 a year. So
And
maybe 1,000.
1,000. And of those employee discipline cases, how many involve situations where the conduct in question was a choice about a book or a curriculum?
I can't specifically remember 1,000 cases and what they may or may not have contained.
It's not a frequent occurrence, though, is it?
No, I would say it's not a frequent occurrence.
And it's less frequently that the selection of book will get an employee terminated, true?
Can't speak with 100% accuracy on that, but in general terms,
Not a common occurrence, is it?
correct.
And of the cases that had resulted in termination, if there were any, how many of those cases involved no preliminary discipline whatsoever, pursuant to a progressive discipline policy or any other policy that would allow for suspension, letter of direction, letter of concern, right to termination?
I couldn't speak to that.
But Cobb County does have a policy of progressive discipline, correct?
Say that again, sir?
They do have a policy for progressive discipline when dealing with employees, correct?
It is in our policy, yes.
But in, actually, I'm going to show you an exhibit. We'll mark it Educators Exhibit 3. Any objection?
Ms. Colvis, have you seen Educator 3?
Yeah, yes, Your Honor. In fact, there's another exhibit.
Okay. No objection, though? Ms. Colvis, I assume, though, you have no objection to Educator 3? All right, it's admitted without objection.
Is this the policy you're referring to? I asked you about policy.
Yes, it is.
This is the progressive discipline policy, correct?
It is a discipline, suspension, and dismissal of staff policy, yes.
On page 1 of the policy at A1, it says the district utilizes progressive discipline in which disciplinary actions follow a gradual escalating path. Isn't that correct?
Correct?
And they, depending on the seriousness of the offense, you could be moved along the continuum pretty quickly, correct?
That is correct.
But according to the policy at number 3, permission must be obtained for Employee Relations Office prior to a supervisor making an exception to the process. Do you see that? It's that A3, second sentence.
Yes.
And in fact, if you don't get that permission, it results in disciplinary action for employee relations, I'm guessing, correct?
I suppose if you're asking me, what do you ask?
You have to get permission if you want to jump steps in the progressive discipline policy, correct?
Yes.
And if you don't, you get in trouble, correct?
Correct. Well, I don't know what you mean by get in trouble, but go ahead.
That's fair. But in this case, Ms. Rinderly's case, she hadn't received any lesser discipline before recommendation for termination, correct?
She had not received any discipline. That's correct.
So there was a decision by employee relations to deviate from the progressive discipline policy, correct?
That is correct. We skipped discipline. Yes.
And you sought approval of that from who?
What do you mean, sir?
Well, it says here that you have to get permission to deviate from the progressive discipline policy.
I believe you're interpreting that wrong.
Permission must be obtained from Employee Relations Office, not that the Employee Relations Office must receive permission.
So you guys can jump to termination without approval?
Correct. So
All right,
at a
hold on.
local level,
Let's don't everybody talk at the same
I don't
time.
have,
All right,
I'll
let's-
withdraw the question, I'll restate the question,
right.
just to be clear. So you guys can jump to termination without having to get approval from anyone, is that correct?
yeah, human resources can skip progressive discipline, correct?
And when they do that, they're making a determination that the behavior is so egregious that it warranted an immediate disciplinary action, and that no lower form of reprimand or suspension would be appropriate, is that right?
That is correct.
So did you make that determination?
I did not.
Who made that determination?
I received that determination from the Chief Human Resources Officer.
Who's that person?
That's Ms. Keely Bowen.
Did you communicate a recommendation to Ms. Bowen?
I did not.
Did anybody from employee relations do that?
I don't have knowledge of what other folks in employee relations may or may have done, but it would have come through me, and I did not.
Okay, did you, based on your review of the evidence and the summary of findings, would you say Ms. Rinderly's case is rare or a serious case when compared to other cases?
Yes, I would say it's very impactful. I would say it's rare.
When you say impactful, is that because it deals with the policies and controversial issues and divisiveness and sensitive material?
Yes,
And you say it's impactful, is that because it deals with the parents, impacts the parents' Bill of Rights?
yes, and the students.
Well, I'm asking you specifically about that policy, the Parents' Bill of Rights that you testified about.
Yes, we do feel it violates the Parents' Bill of Rights, correct?
So I don't know that you testified to, but you were aware as part of your investigation that a parent complaint was made that initiated this incident, correct?
I don't know if I testified earlier, but I do know a parent complaint, yes, came across in this scale.
In your experience, how many parents' complaints are required for a matter to reach this level of termination?
Parent complaints don't dictate discipline, sir.
So the parent complaint had nothing to do with the summary, with the recommendations for termination?
Not at all, sir. Parents complain every day in every school building.
They do, don't they?
Yes, sir.
Tough job. Did you read any of the complaints that were related to Ms. Rinderly's reading of My Shadow is Purple?
I may have seen one email.
And did those complaints concern you?
Do the complaints concern me?
The one you reviewed, the one email?
I can't speak to it. Is it an exhibit?
I'm going to show it to you. I'm going to find it and show it to you. Exhibit 8 of the notebook that's in front of you. And this is the district's Exhibit 8. Sorry to be jumping around. Do you recognize the email?
I've seen it at some point.
So this is one of the emails that was part of the investigation, correct?
What do you mean by part of the investigation?
Did the investigator who conducted it and make it part of the investigative file include this email?
Okay, yes.
And you reviewed it when you were making your recommendation or determinations as to what to do next, correct?
We don't necessarily take into account what the parent is asking to do. It's not a parent-driven process. This is an investigative process, so.
Not asking
No, I'm not looking at this and saying this is impacting.
All I'm asking
Well, maybe
is,
it's
was it part of the
going-
investigative file?
Yes, it may have been in the investigative file.
And it's true that there were also parents that sent emails in support of Ms. Rinderly, correct?
There may have been one or two as well.
Can we do them as two different numbers?
Where's the short one?
Thank you.
Any objection, Ms. Coles? This is educator exhibits 4 and 5. Good, Mark?
Yes, sir.
Sir? Mr. Goodmark, just for the record, which one is 4 and which one is 5?
The short one is 4, the long one is 5.
Okay, thank you.
In the course of the investigation, do you recall seeing the letters or emails of support that were sent?
I've seen them at some point, yes.
These weren't made part of the investigative file, though, were they?
I'm not aware, sir.
We asked for the entire investigative file, and they're not in there, so if they were part of the investigative file, they would have been in there, correct?
I would say yes.
Your Honor, I object these documents were produced to Mr. Goodmark from the school district, so the insinuation
So here's the problem.
that is incorrect.
she wants to play fast with open records and fair dismissal, but I made an open records request. I don't know if it's in the investigative file or it's not in the investigative file, so I have to ask. And
Well,
because
you've asked, and he's
yeah,
answered.
he said it was. And so, I mean, because who knows at this point?
But let's move on. You've asked
Sure.
and answered.
And so these were not part of the investigative file. Do you know, looking at those documents, whether or not the students of those parents were brought in for interviews?
From these redacted versions, I can't tell.
Well, I know that both those students are African-American students. Did you interview any African-American students?
Again, sir, I didn't conduct the interviews.
Are you aware of whether or not there were any African-American students interviewed as part of this investigation?
I am not aware of any of the race of any students in Ms. Rinderly's class, sir.
You had testified about the sensitivity of this book that you're talking about. Do you consider gender identity to be a controversial topic?
Yes, I do.
Do you consider it to be a political topic?
I do.
Why?
Why is it a political topic?
Why is it controversial?
If it wasn't, we wouldn't have cameras back here, sir. Are we? It's very politicized. It's one of those highly politicized topics there is.
No, my question, is it controversial?
Yes.
Because the media is interested in it. Is that what you're saying?
No, I'm saying it's an issue that has a lot of feelings, depending on the person, depending how they're raised, depending on their family, depending on their religious background, depending on their moral beliefs. So yes, I do feel it's controversial.
I think you testified that gender identity and gender fluidity is part of religion and morality, and is a part of, it serves to dictate the gender identity and gender fluidity issue. Is that right? That was your testimony?
I don't know. If
Do you
that
remember
was my
talking about
fact.
religion and morality?
I do. I do
Right.
remember.
The tribunal heard it. Is that always true?
What do you mean, sir?
Are atheists don't have an opinion about gender identity?
Oh, yes, I'm sure they can.
So it's not
Absolutely, sir, yes.
necessarily about religion, is it?
It is not necessarily exclusively about it, no.
And the existence of boys and the existence of girls doesn't depend on people's morality, does it?
It does not.
And the same would be true for the existence of people who use a different pronoun, correct?
Say that again?
Their existence of somebody that refers to themselves as they, them, or somebody that's gay, or somebody that's a lesbian, doesn't depend on somebody's morality, does it?
The individual? No, not at all.
And their existence doesn't matter to somebody's morality. They exist, right?
The individuals exist? Yes, sir.
Have you read the book, My Shadow is Purple?
I have.
Did you read it before the investigative conference?
I
with
did,
me?
yes.
Let me finish. Did you read it before the investigative conference with Ms. Rinderly on the 24th?
Yes, I did.
You said the book was clearly about gender identity, isn't that right?
Correct.
Is the book only about gender identity?
In my opinion, its main theme is gender identity. Yes, sir.
And I think you testified differently from what you just said. That's about inclusivity, right?
I did testify that at the end of the book, there's a part where they're very inclusive. Absolutely. Yes, sir.
And if you can turn to page 1 of the book you have in front of you. Is there anything controversial about page 1 when the dad has a shadow that's blue as a berry?
Sir, I don't. Are we going to line item through this book?
Mike, we got to figure this out. This is a policy that nobody understands. And so
Your Honor,
there's-
there's a good background in evidence. I think a lot of people understand this. House clerk.
sustain the objection. Rephrase your question, Mr.
Question
Goodmark.
was, is it controversial that the dad has a shadow that's blue as a bear?
Your Honor,
This is ridiculous.
this witness has not testified
Ridiculous.
that there's a one line in this book that's controversial. He's testified that the entirety of the book, the topic of the book, is politicized, is controversial, is sensitive. Asking him to go through, first of all, we're never going to leave here tonight, but asking him to go through here and identify each line and whether it individually on its own is controversial is counter to what he's testified to.
All right, I'm going to overrule the objection, but I am going to ask you, Mr. Goodmark, to, please move on. I mean, I think you've made your point, so let's
It's not
move on.
all far. I just got to finish it, right? Because this is the person who made a decision as to whether or not this was sensitive or controversial. And that it actually, as pursuant to the policy, takes one side of the issue. And I'm asking him, it's not controversial that the dad is blue as a bear, right?
I don't even know how to respond to that.
Your Honor,
No.
and so they don't know how to respond.
Yeah,
He doesn't, but he was
Don't
the
even
person
respond.
that's responsible.
I understand.
Policy, he can't help.
I understand. He's answered the question, though.
Yep, and
Move
I'll
on.
ask the same question. It's not controversial that the mom is pink as a blossoming cherry.
Don't know how to respond.
Can't answer
to
that one either? That's okay. I mean, you can't answer it, that's fine. Is it controversial that the dad's wearing suspenders and pants?
Again, sir, I'm here to weigh in on the content of the entire book, not
I'm
the
asking,
little,
the content of the entire book
Picks.
consists of page 1, doesn't it?
I'm sorry,
The contents of the entire book includes page 1, right?
as being cumulative, the contents
Does
of
it
the book,
include
sir.
page 1? Well,
It would.
let's talk about page 1. It's not controversial that he's wearing suspenders and pants, is it?
I suppose not.
It's not controversial that she's wearing high heels and has long hair, is it?
Suppose not, no.
Which part of this book, point me to a page that is controversial in your professional opinion?
I would say that the book as a whole is controversial because it does not fairly present a balanced view of this issue.
Let's talk about the whole book.
Yes, sir. Let's do
The
it.
book doesn't contain any sexual content, correct?
Does not.
It doesn't contain any sexually suggestive content, does it?
Do not believe it does?
You believe it does have sexually suggestive content?
Say do not.
Do not, I apologize. It doesn't contain any obscene content, does it?
No, sir.
It doesn't contain any descriptions or references to nudity, sexual content, or sadomasochistic abuse, does it?
No, sir.
The book, in your words, is about gender identity because it involves colors and traits associated with certain genders. Is that right?
In simplistic terms, yes.
If the main character's colors were red and green on that page instead of pink and blue, would this still be controversial to you?
I think you're oversimplifying this issue now, just trying to make it about colors. So if we're looking at this character and the journey that this character is on, this is an individual who is at the end of this, because they're not sure their likes, their dislikes, at the end is dressed in what would be considered traditional female garb, traditional male garb up top.
That's controversial.
I think to a portion of the public, absolutely. Yes.
Harry Styles was on the cover of Vogue magazine in a dress. Is that controversial?
I'm not familiar with Harry
I'm
Styles.
trying to understand where the limits of this are. I'm sorry.
Let Ms. Culvis get her objection on the record.
I hope Mr. Goodmark is not going to suggest to this tribunal that it's appropriate for fifth grade students to read Vogue magazine
Controversial is determined by the community. I'm allowed to ask things that are in the community to determine the limits of what's controversial.
Yeah, I think the last question you asked, though, is beyond the scope. I'm gonna sustain that objection.
That's fine, that's fine. Ms. Rinderly told you that she didn't have a lesson on gender identity, isn't that correct?
Yes, I believe that's what she told me, yes.
And in fact, she told you that the lesson was about inclusiveness and acceptance, correct?
Yes, that's how she framed it, absolutely.
And you based your recommendations for termination on the fact that there was a lesson about gender identity, correct?
Correct.
Okay. When you made that recommendation, had you spoken to the superintendent?
Thought we established earlier I didn't make the recommendation.
Had you spoken to the superintendent in the course of this investigation?
I have not.
Did you engage in any email correspondence with the superintendent?
I did not.
Did you have any phone calls or video calls with the superintendent about Ms. Rinderly?
I did not.
Did you have any in-person meetings with the superintendent about Ms. Rinderly?
I did not.
Can you go back and look at policy IFAA? It's exhibit 2 in the I had asked you earlier about your communications with the superintendent. I'm going to ask you now about your communications with the superintendent's office. Did you have any communications with Keely Bowen about this situation?
Yes, she's my direct report.
When were those?
In the course of normal business practice.
What date?
I don't know, she's my direct supervisor. I see her quite frequently.
Did you see her on March 24th, after you had your meeting with Katie Rinderly?
I couldn't tell you.
Did she communicate any directives to you from the superintendent's office about how the case should be managed?
She did not.
Did you engage in any email correspondence with Ms. Bowen regarding Ms. Rinderly?
I don't recall.
If you had engaged in the email correspondence, you would have given them to your counsel because those are pursuant to an open records request, correct?
Absolutely, yes.
I think we established, I asked you a few questions about harmful content to minors. Is it your position that My Shadows Purple contains divisive concepts as are defined by the policy?
No, sir.
What is a divisive concept?
Your Honor, the relevancy is just that the book does not constitute the advice of content.
That's fair.
Where we're talking about.
That's fair.
I sustain that.
In the charge letter, it was listed that IKB-R, and that's, I believe, what exhibit is that of your notebook? Exhibit 4 of your notebook? Do you see it there?
Oh, yeah, I do.
Okay.
We're not looking at the charge letter now.
No, we're looking at the policy Exhibit 4 in the witness notebook. Administrative rule, IKB-R relates to the controversial issues, that's what it's titled.
Correct.
This policy was cited in Katie Rinderly's charge letter. What section of the policy did Ms. Rinderly violate?
If we go down to section B, where it says political partisan issues, and I believe here we have subsection 3. It says, as addressed in OCGA 20-2-786, parents have the right to direct the upbringing and the moral or religious training of their children. Therefore, district employees shall not improperly infringe upon this right.
And your investigation found that she improperly infringed upon a parent's right to the upbringing and moral religious training of their children?
That is accurate.
What's the evidence of that?
The content of the book, as we stated earlier, we believe that that infringes on the religious and moral upbringing
The book
of the
itself?
parents' rights.
The book itself?
The content, yes, sir.
Okay. And nothing else? It was just the book itself?
Well, we could also address Ms. Rinderly's instructing them to use, or refer to the main character as they instead of he as well.
Well, that was disputed, right? Some students say she didn't do that.
She acknowledged she didn't.
Hold on.
She testified that she gave them.
Let her get her objection on the record.
My recollection of Ms. Rinderly's testimony is that she told the students to refer to them as they. She described the debate between the students, and some of the students referring to the character as a boy, and she told them to refer to the student as a they. That's what I recall Ms. Rinderly testifying to.
We have a transcript and the tribunal can,
That is what she said.
there's no question for him.
I'm sorry?
Move to strike the witness statement.
I haven't heard a witness's statement.
He made a statement, I'd move to strike it.
For reporter.
He said that's what she said. There was no question. Move to strike it.
So let's go back to the original question that you had, Mr. Goodmark.
Sure.
What is your question? Let's restate the question.
Question was, it was the book in its entirety as he testified, which is what Ms. Rinderly is cited for when it comes to IKB-R. The book itself is the evidence of the violation of B1. Excuse me, B3, correct?
Ms. Coles, do you have an objection to that question?
I missed it.
That's okay. Ask it again,
I
Mr.
just-
Goodmark.
The question was, the book itself was his testimony, was the evidence that Ms. Rinderly had violated B3 of the policy.
Okay, and
Do you have any objection to that question?
that question?
Yes.
I mean, I don't know that Mr. Dowd is an expert on these.
Well, but, I understand, but he's got him on cross, so,
I mean, then ask what everyone says.
okay, yeah. All right, so having no objection, witness can answer the question if you can remember it.
I mean, I think I see where Mr. Goodmark's going with this. So, I mean, the book being instructed as part of a whole class lesson plan, yes, sir.
And she told you that the lesson wasn't about gender identity, correct?
And the students told me, or some of them felt that it was, so yes,
Those students inconsistently, right, reported what happened in that class.
which shows it's controversial.
I think it
by
shows that
nature, because
students
we have
can't
different
remember
people
what happened 12
perceiving
days
it
ago.
Differently.
Mr. Goodmark, you know better. Ask questions if you have questions of the witness.
2 seconds, probably done.
Yes.
No further questions of this witness at this time.
Ms. Colvis, you need a break, or are you ready for your redirect? I mean, for your,
If I can have 1 minute, then I can probably finish you up.
fine.
Mr. Dowd, and I appreciate your patience as I'm trying to hop back and forth between a couple issues that you've been addressed.
Yes, ma'am.
Mr. Goodmark asked you about the School District Exhibit 10, the summary of findings. Is this summary of findings, and so if you'll flip to it, please. Is this summary of findings intended to be a comprehensive narrative of every single piece of evidence that the school district obtained in the course of its investigation into this matter?
It is not, ma'am.
Okay. And the 4 students that are referenced in the summary of findings, were those students interviewed by your office, or were they interviewed by someone else?
The 4 students referenced were interviewed with Employee Relations and Ms. Kale.
Okay. And the other 4 students that, when you add 4 plus 4, we get to 8, did your office interview those students directly, or did somebody else interview them?
Ms. Kale interviewed them.
Okay. Is that why their feedback is not included in this summary of findings?
Yes, ma'am, I'd assume.
Mr. Goodmark asked you about the picture not being in the investigative file. Where did the school district get that picture?
I believe it was sent to Robert Reinierson from Ms. Rinderly.
Okay. And so Ms. Rinderly clearly had a copy of that picture before she came to the hearing today, didn't she?
Yes, she submitted it to Mr. Reinierson.
Okay. Does that picture prove to you when, the date and time, when Ms. Rinderly had the fraction riddle?
There is no date or timestamp on it, no.
Okay. Are there any other students other than the one student standing in front of the whiteboard shown in that picture?
No, ma'am, it's just one student.
So can you draw a conclusion from that photo as to whether the whole class engaged in that intervention or in that moment?
Not from the photo, no.
And I just want to clear this up because I may have said something confusing earlier, so I just want to clarify the record. What date did your office interview the 4 initial students?
That date would have been March 20th.
Okay. And mathematically, can we all agree that's 12 days after March 8th? Very good. What date did your office interview Ms. Rinderly?
March 24th.
We had some questions about student consistency in their statement, so we're going to look at the summary of findings for a moment. And I've just gone through and numbered these students 1, 2, 3, 4 to keep myself in order. Did the first student tell investigators that when they were discussing the cover, the class was referring to the main character as he? Ms. Rinderly got mad at them for calling the character he. She said it was biases and stereotypes about the character wearing a blue button-up shirt, short hair, and glasses. She told the class to refer to the character as they and them.
Yes, ma'am.
Did the first student tell investigators that he could tell other students in the class were uncomfortable while Ms. Rinderly was reading the book?
Objection, hearsay.
Yes,
Well, the
ma'am.
documents,
Making my objection. Got to make the objection.
that's fine. It's noted for the record, but the
Okay.
document's already in, and I've given them limited instruction as to exhibit now. But so you can ask the question.
Yes.
folks.
Did the second student, at the bottom of that page, and then moving into the next page, tell investigators that students referred to the character as he and him? Ms. Rinderly responded with, "Do you know it's a he or not? There's a stereotype about how girls and boys act." And then, let me ask you that question. Did that student tell investigators that?
Yes.
And did that student tell investigators that she did not tell the class to refer to the character as they and them?
Yes.
Okay. And that's the question, the line of questioning that Mr. Goodmark asked you about a little bit ago, correct?
Correct, ma'am.
Okay. But am I right that that student still said that she responded to him, "Do you know it's a he or not? There are stereotypes."
That is correct, ma'am.
Okay. And moving on, third to the last bullet point for that same student, did that student say that he felt as if Ms. Rinderly was sharing her opinion with the class about biases and stereotypes?
Yes, the student did state that.
Did that student also tell investigators that he feels she is pushing her personal agenda on the class, and she did not do it that much last year?
Yes.
And he thought she was a good teacher.
Correct.
Yeah. Did that student, and let's go to student number 3. Did student number 3 tell investigators that students were referring to the character as he? She told them to refer to the character as they and them. It's they, not he.
Your Honor, the document
Yes,
speaks for
ma'am.
itself. She's doing nothing but rereading the document into evidence. It's already in evidence. It can't be used for any probative value because these are hearsay statements. The difference is we don't have a burden. We're defending. They have the burden to prove something, and they can't rely on this by simply creating a running narrative by reading something from somebody else said or may have said or may not have said from outside this courtroom. That simply is inappropriate, and that's what she's doing.
May I respond, Your
You
Honor?
may, Your Honor.
The
You may,
reason
Your
I'm doing this is because Mr. Goodmark made an insinuation that these students were not consistent.
Yep.
And I'm demonstrating to this court that, if I can get to the end, that there was consistency. I wouldn't have gone here if Mr. Goodmark had not objected to the testimony that they were consistent.
All right, I'm going to allow it for that reason, but I will say that, the document is already in evidence, so I'll ask you to kind of be as quick as you possibly
Yeah.
can.
Let's, student 3, students were referring to the character as he. She told them to refer to the character as they and them. It's they, not he. Is that correct? Bottom of,
I'm sorry, what student are we on the 3 still?
we're on student 3. It's the 1, 2, third page, the one that started at 1:10 p.m.